Supplementary list. Item number 1, pronouncement of judgment.
So, as the Meghalaya Directorate Establishment Ministerial Service 2010 has amended our statutory rules made under Article 309, written instructions such as the Impugn Office Memorandum can contain provisions not covered by the rules. They, however, cannot override, supplant, substitute statutory rules. The judgments placed by the counsel of the petitioner lays down a settled position of law and need no further elaboration or discussion. The judgment placed Leonard EAG or Union of India so-and-so in fact supports the case of the petitioners, as has been held that the government can fill up gaps and supplement the rules, but the same should not be inconsistent with the rules already framed, and that the law laid down that has consistently been followed is that authority cannot issue orders, executive instructions in contravention of statutory rules. Clause 5A and 5C of the Office Memorandum, as seen from the discussions, being offensive to the statutory rules as framed, therefore unsustainable in law, and accordingly struck down. Consequently, the orders also impugn writ petition, namely DPC dated so-and-so as far as petitioner at Agenda 3 thereof, reversion order dated 2/7/21, office order dated 14/6/2022, hereby set aside and quashed. It's further directed that petitioner be restored to promotional post LDA forthwith, and a service in the said post LDA be counted from the date of promotion as 10/12/2020, and further be allowed all consequential benefits. Yes. Petitions are allowed, yes. Yeah.
Any mention?
Wait, please, Your Lordship.
Yes. Yes.
Also, I will be permitted to move an unlisted motion, Your Lordship.
Regarding?
Lordship, this is with regard to the Tura Daru Road, NH 51, Your Lordship. This notification was issued way back in 2019, Your Lordship, after which we filed objections. Thereafter, then there was no response. We have not been given any hearing. And all of a sudden now we have received this notice dated 15 July asking us to vacate by today, or else action will be taken by the administration, Your Lordship. So we have for Your Lordship.
Okay. We'll see. When did you receive the notice? 15th? 15th?
It is issued on 15th.
When did the petitioner receive it? When did the petitioner receive it?
It's not been issued individually. It has been issued jointly for all the...
Okay. Yes. Yes.
Lordship, in item number 30, 30, Your Lordship, we have just received the rejoinder affidavit.
Who's there? 30, other side?
My Lord, I am the petitioner, my Lord.
Dashim T. Kharkumar.
Yes, my Lord.
So we need 2 weeks' time. 2 weeks' time.
2 weeks.
As the counsel for respondent number?
4.
4 has just received rejoinder. He prays that the matter will be 1 week only. Matter stands adjourned to
1 week? My Lord. Obliged.
Yes.
May I please, Lordship, I beg to mention item number 24, Your Lordship.
Swastamani coach.
Yes, Your Lordship. I humbly pray that this matter be taken after 2 weeks, Your Lordship.
Why?
Need some more time to prepare, Your Lordship.
Don't make the excuse. Yes.
No objection.
No objection. Take 4 weeks to prepare. Okay? 4 weeks time as prayed. Allowed to the respondent. Yes. No urgency.
No.
Any urgency, Mr. Siddiqui? Yes, very good. Interim orders continue until further orders. Yes.
Actually, Your Lordship,
No interim order, it was already...
the interim order was passed not till for the order, Your Lordship. It's, the interim order was...
Till today?
No, Your Lordship, not till today. It's till...
It's already passed for the orders?
Yes.
Oh, then no need. Yes, okay. Yes.
All right.
Yes.
May I please, Your Lordship. Lordship, I beg to mention item number 29.
29th. Yes.
And the lordship has directed us to just provide the notification before the form of the report. Otherwise, there is something in this matter.
What notification?
Notification which provides that the entity norms are binding and any candidate not possessing DH degree should not be appointed as witnesses. So the government
Where,
has,
who's appearing, Mr. Hassan?
No, Your Lordship. The arguing counsel is S. Islam. He's from Guwahati. He's not present today. Kindly adjourn the matter for today, Your Lordship.
How much? 4 weeks?
2 weeks time, Your Lordship.
Take 3 weeks then. Yes.
Your Lordship.
Give you ample time. But I don't want to adjourn it to next time. Don't take any adjournments. Yes.
Your Lordship. Much obliged, Lordship.
Yes.
Lordship, I beg to mention item number 27. Sir, M. Chanda is on the other side, Lordship.
Who's another side?
M. Chanda.
27? No.
Joseph Sebastian.
Who?
Joseph Sebastian.
Yes.
Lordship, I pray if you may kindly take up this matter after 2 weeks.
2 weeks. No objection. Yes. Yes.
Lordship, and item number 28.
Two weeks, yes.
Obliged, Lordship.
When is he coming to court? Any idea?
Lordship.
Supplementary list, item number 2.
Yes. What's this?
Your Lordship, this is the second round of litigation. Your Lordship. What has happened, Your Lordship, the petitioner has filed application before respondent number 2, Your Lordship, under section 8 of the Meghalaya Land Transfer of Land, Your Lordship. Then the respondent number 2 endorsed it to respondent number 3 to dispose of the matter.
Who's respondent number 3?
Additional revenue, Your Lordship.
Okay, then.
Then after that, Your Lordship, the respondent number 3 has not did not pass any order, Your Lordship. So the petitioner left no order but to approach before this court, Your Lordship.
Where's the order of the Deputy Commissioner?
In page 66, Your Lordship.
Additional Deputy Commissioner. Page?
66.
So you're citing violation of the civil revision or writ?
No, Your Lordship, this is for violation of section 3, Your Lordship.
Yes. 66 is the last order here. No,
Yes,
where's the
Your
order of the Additional Deputy Commissioner, you said?
69, Your Lordship. Then the respondent number 3 heard the matter on 27, Your Lordship, and he refused to exercise his jurisdiction and reject my application, Your Lordship. Despite a clear provision, Your Lordship.
Who's this EDC? You don't write the name also, Tom.
A.G. Mumin.
E.G. Movement?
Yes, which is in page 70, Your Lordship.
Yes, Mr. Sen, what is this?
It's the fact remains this is an appealable order. It's under section 8, subsection
revenue?
4, Lordship.
You take instructions?
Lordship.
Heard Mr. Dinyota issue notice, Mr. You accept notice for on behalf of?
6.
Mr. Essence, present.
1, 2, and
on
3.
behalf of 1, 2, and 1, 2, 3. Mr. Lemon Omri is present with number 6, notice to issue to numbers 4 and 5 within 3 days. Just after 3 weeks.
Obliged.
Yes.
All right, Your Lordship.
Item number 3.
Yes, Mr. Sabha.
Lordship, here I'm aggrieved with the actions of the respondent number 3 and 4, my lord. Here, my lord, the petitioner here is a serviceman in the working, my lord, engaged in the Assam Rifle, and my lord, he's on the sports quota, my lord, sports category. He's a boxer by my lord trade, and my lord, he wanted to, my lord, represent the state in various national and international events, my lord. And for that, to that extent, my lord, he had obtained NOC from his superiors in the Assam Rifle, which was allowed, my lord. Now, subsequently, my lord, there is a process, my lord, where every athlete who wished to represent the state is required to undergo, my lord, trial. Now, in this case, my lord, the respondent, the petitioner, my lord, when he presented himself for a trial, my lord, he was denied permission. Now, for what reason, that was not told, my lord. In fact, he was...
Where is that denial permission?
My lord, it is not there, my lord. I'll just show your lordship the permission that was granted to me by my superiors. Now, it is my case, my lord, without giving any reasons in
You will
writing.
take part in which event? Olympics?
My lord, future events. Now that event, my lord, for which I had presented myself has already passed by, my lord. So I have no say over it. I only wish, my lord, that I only pray that, my lord, in further future events.
Which weight category?
Beg your pardon, my lord.
What weight category is he?
My lord, he is in the category of
60 kilos.
60 kilos, my lord.
Yes. Why not selecting? He's a rifleman and he's a local also. Why not? Why is selecting him to represent the state?
My lord, we are only appearing for respondent number 1, my lord. And respondent number 2
Now,
onwards, my lord.
who are his main respondents 3 and 4? But is address sufficient?
Yes, my lord.
Meghalaya Boxing Association. Where's the office?
My lord,
who's the president of Meghalaya Boxing Association?
That we are not aware of, my lord.
Then you'll have a problem with the service of notice. You find out.
We'll ascertain, my lord.
This is information on Monday. Meanwhile, you find out. Otherwise, what's the point of just giving empty notice? He'll return back. If it's true, I mean, why should a sportsman be deprived? This is what happens. Yes.
Apologize, my lord.
Daily
Yes.
list item number 1.
Contempt petition, my lord. The orders, my lord, that page 11 onwards, my lord. This order, my lord, was passed on 5th of September 2023, my lord.
2023,
my lord. So it's more than 10 months and no steps has been taken by the department, my lord.
What's the matter about?
My lord,
what order? What was the direction?
Yes, your lordship. What happened, my lord, in this matter, we had filed a writ petition, my lord, for special recruitment, my lord, of the persons who have been serving for more than 15-20 years, my lord. And even in the appointment letter, my lord, it's provided there that they will take part in the selection process by MPSC. Now, in the last 15 years, my lord, no selection process was conducted. So, in terms of a previous case, my lord, where this Honourable Court had allowed such process, so this Honourable Court had also directed that kindly...
Nothing has been done?
Nothing has been done. It was more than 10 months, my lord.
Mr. Petitioners, issue notice returnable in 3 weeks, steps to taken by AD within 3 days.
But Dustin addition.
Let's go first.
Deeply.
Item number 2.
May it please, Lordship, here the petitioner's deceased husband, he was a retired employee of the Karoli District Council, Lordship.
Retired?
Retired employee of the District Council, Lordship. Now what happened? His gratuity was not paid. Then the gratuity was not paid, Lordship. Then he came to this Honourable Court, and during the pendency of the writ petition, Lordship, they have sanctioned the amount, Lordship. That is at page, Lordship. Page 21, Lordship.
Okay. 2,94,000.
94,000, Lordship.
Yes. Then what happened?
Thereafter, this Honourable Court has directed the respondent to pay the interest. Accordingly, interest was paid, Lordship. Now, since there is a dispute with regard to the calculation of the gratuity, Lordship, because as per the petitioner's Lordship, the gratuity ought to have been 6,87,000, Lordship, because the similarly situated who were appointed on the same day and more or less retired on the same time, Lordship.
Yes.
That is at page, Lordship. Page 22, Lordship.
Yes.
This is the Ravindra Nath Kos.
Yes.
His gratuity was calculated and sanctioned at rupees 6,82,000, Lordship. Date of
same post he's serving.
Same Lordship.
What post he's serving again?
Lordship will come to page 10 Lordship. Appointment order Lordship. Serial number 10 is the
Petitioner.
petitioner's husband.
Ranjit Coach.
Yes, Lordship.
And 11
And
is?
11 is the Ravindranath Coach. Just now I have referred the sanction letter, Lordship.
Secretary means what post is this secretary?
This is the Village Council Secretary, Lordship. Village Council. This is
under the district council?
District Council, Lordship.
What is his function?
This is like Village Court, Lordship.
Village court?
Like Village Court.
Village court is different, it's run by the village.
That is, Lordship. This is only in the Moja area, Lordship. That posts are lying.
Zigzag, Mandraganj, Rajabal, okay.
Even
or Plains area?
Yes, even here, Lordship. Lordship will see that Latifur Rahman.
Yes.
Latifur Rahman, he is also Village Council Secretary, Lordship. He retired on 2014. Kindly see the amount of gratuity, Lordship.
Have some loans you took from?
No loan. If there is a loan, Lordship, at least in every order they is to write that subject to the deduction of so and so, Lordship. Page 25.
This is the same, Latifur Rahman?
Latifur Rahman, Lordship. What they calculate, Lordship?
How come it's got 9,43,000 then?
Yes,
the Rabindra Coach got 6 lakhs.
Because he retired in 2014, Lordship.
Who?
That Latifur.
Okay.
He retired in
And
2004.
your precious husband retired on?
2011.
So the formula is different.
Yes, Lordship. Another aspect, Lordship. If the amount of leave salary is rupees 2,000, example, then the gratuity will be 6,000, Lordship, because they have calculated in the same manner.
Anyway,
thrice the amount of the leave salary,
I
Lordship.
have taken instruction, my lord. These are all.
Yes, sir. But Mr. S.A. Sheikh issued notice. We'll come to the calculation later when they file affidavit. Mr. S.D. is present, except all respondents, no further notice required. Just a matter of 3 weeks for instructions affidavit. Yes.
Hello.
Item number 3.
3A. Number 2. Any staff.
May it please your lordship.
Yes.
No, this is a case, my lord, if your lordship recollect, at the stage of motion, my lord, I have raised the objection that similarly situated person already approached this court. And after detailed hearing, my lord, regularization was refused. So, my lord, I was supposed to pay, my lord, I have submitted a copy of the judgment. Now, my lord, the other thing is this interesting thing, my lord, when I was going to be around 30 number of petitioners, they came before this court. And this writ petitioner was also a party there, serial number 22.
Oh. Serial number 30?
22. 22.
Dining star Dakhar.
I don't know what remains, your lordship. That was dismissed.
I was not aware of that, lordship.
Withdraw it, otherwise.
I apologize for we are not.
Otherwise, your petitioner.
It was not disclosed
Under
to me.
whose advice did he come to the court again? This order's appeal against.
Some of them they preferred an appeal. That was also not pressed. That was also closed.
See, Mr. Lata, you kindly see this judgment. Yes, is number 22. If he's the same, yes, same dining star Dakhar. It has been pointed out by the Senate Counsel for the respondents, number 4 and 5.
Number 4 and 5.
That on the same cause of action, the writ petitioner had already approached his court along with other similarly situated petitioners by way of Loud PC bracket SH113 authorized. If Mr. D.K. Datta
May I get a
submits that he is not aware about the same, directed to stop. According to obtain instructions, this is the matter on Monday.
Monday.
You take this back or we keep it here. Sometimes ignorance, sometimes they get over smart.
Yes. It was not disclosed to me, Your Lordship.
Well, it happens.
I was not aware about it.
Supplementary list. Item number 4.
sometimes they're very smart. They don't give the correct papers, and lawyer thinking only the good one. They don't know will be revealed by the others. Yes. Yes. So what have you settled at?
My little friend, my little friend, Mr. Pandey, was supposed to seek instructions about
Yes. Yes.
I have the instructions for the corporation laws. For the corporation laws, it won't be possible to agree for any compromise settlement as far as the fixed charges is concerned. Because that would set a bad precedent for all customers, and basically then customers can violate the regulation and then seek for reduction in the fixed charges.
So no, it's in the facts, circumstances of not every case is the same. This case is different in a sense that there was a proceeding pending.
Yes, but I am bound by the instructions. These are the instructions of the corporation.
If I may, it can fall as an order from your lordship.
Yes.
Maybe my friend may be in difficulty in.
What was the proposal?
Only case is here. This is a case. This is a situation completely a departure from the previous proceedings.
Yes.
Because this is a case of absolute non-compliance of the regulation. So even if this is seen from that perspective, you have to comply with the regulation 6.4 to get a benefit of reduction in the fixed charges. That has not happened.
No, but the thing is that you had settled it. Okay, fine. You'd given your arguments that you are bound by law to keep on renewing your demand, because if you don't, then it will show that you have.
In fact, that is not under challenge. If sees the prayer, if sees the prayer, that is not under challenge. The remaining aspect. The only fixed charge component has been contested. See page number 12 of the writ petition. 12 and it continues that.
See, the situation has changed now. Whatever is come for this court does not survive any longer. The only thing is that they will send it back to the commission, let them thrash it out together with the other. Otherwise.
This matter is not pending before the. My lord, this matter is not pending before the commission.
No, because this cause of action is gone also, Mr. Fall. He said the period for which this connection has been sought is over.
My lord, the only issue that remains now is whether they can charge us for that period or not. Because
Exactly.
The consumption is zero. The consumption is zero. There is an interim order that is operating. They cannot deny the fact that there is an interim order operating in this matter.
Because interim order, in my humble submission, would come into play only after you satisfy the conditions of the regulation. That has not happened. So interim order was there or not there would not accrue any benefit to the petitioner, because the regulation says that it has to happen by the corporation, the disconnection, and they have to pay charges for that. All of that has not admittedly happened, and they have gone paragraph 8, they have admitted in the petition that they are disconnected on their own. So in that context, there is no benefit which the petitioner can seek from this court.
Now the situation is that your unit is running.
Yes.
Current bills are being generated.
Yes.
And the only a segment that remains is during that period where you did not consume any power.
During the period of non-consumption of power, whether this fixed charges could have been charged or not, it will be interim orders passed by this. Because what is happening is, had it just been the issue of a regular matter, this issue would not have come. There has been prolonged litigation. There are orders operating passed by the commission as well as by its own. One is a consensual order. Once there is a consent order, in my humble submission, that kind of demand was absolutely missing. That's the only issue.
Yes, 1 second.
What has fallen from your lordships is balance to balance equities. Your lordships have indicated that probably we will be required to pay for 1 month, and 1 month we will not be required to pay, which in my assumption is a very fair proposition.
Yes, okay, we'll pass orders then, yes.
We have some difficulty in having an acceptance for the corporation.
Because the only thing is that for interim order or no interim order, first they have to comply with the regulation. And then the interim order
Next matter. We'll pass orders. Next matter.
Next matter is the
Enhancement.
The issue here is with regard to load enhancement.
Yes.
And here also there is an interim order which they are saying that there is no interim.
It was very easy.
Yes. Where's the interim order? Dated?
I'll just take a look at the interim order.
Yes.
If my reference can just let me finish.
Yes.
Annex 9, page 26.
Yes.
At page 27 is the interim order. Accordingly, with the consent of the parties, the petition or disposal of the direction to NCRC to decide the pending cases on application to our own merit and accordance with law. With regard to the tariff collected by the petitioner corporation and also the special tariff paid by the responsible consumer data, the same shall be subject to the final application by NCRC. So your lordships have essentially frozen the status quo as on that day. Even assuming, what they are trying to argue that there is no interim order. Fact of the matter remains, there is a specific interim order with regard to the collection of tariff by the Commission on 5/12/2022.
Yes. One second. No, current dues is satisfying.
Yes, sir. Current dues, there is nothing pending. Both these two companies, current dues are paid up.
Now, Mr. Pandey, you are rejecting the request for enhancement because you say procedural enhancement.
There are two issues. There are two issues.
Yes.
One obviously in respect of the interim order, whether there is an interim order, whether there is not an interim order, as far as the dues are concerned, previous dues are concerned. But before that, there's CSC prayer at page 11.
Yes.
It says that in the premises aforesaid, it is most humbly prayed that your lordships may be pleased to admit this instant petition call for recourse, issue rule calling for respondents also, directing the respondents to recall and withdraw the impugned letter dated 3/3/2023. So, my lords, the impugned letter here is from 3rd of March 2023, and my lords, order kindly sees the date.
Yes.
The order is of 15 February 2024. And we'll just see the ground in this respect, para 15 of the writ petition.
My lord, the difficulty is here that they have wrongly quoted
Para 15, just a moment. Para 15 of the writ petition below, the petitioner at page 9.
Yes.
The petitioner submits that the impugned letter dated 3/3/2023 passed by the respondent authority.
Yes, Mr. Paul. On this ground, I don't think we can do any relief.
No, my lords, this is very, very smart of my learned friend to take this out.
It's smart, but it's on record. It's travel beyond.
No, my lords, if your lordships just permit me.
Your assailing order did 3/3/23 basing on a.
This order is dated 3/3/24. They have wrongly quoted 23, so we had to write 23. Can we have a look at page 20?
Yes. 23.
My lords, this is what the original order is, my lords.
See your letter. See refers to your letter dated 1/2/23. So.
It is for 2023, Mullah.
Yes, 23.
Because the interim order passed by the Commission is dated 22, Mullah, 5/12/22.
That's a different thing, Mullah.
Well,
Here
15 to 24.
Order which has been finally frozen by a law.
You withdraw it and file and you be rejecting it. You withdraw it and file it a correct one, a proper application.
Lordship may grant me that liberty.
Yes. As there are some serious defects in the writ petition, Mr. K. Paul has counsel please allowed to withdraw the same. Will it be fresh if so advised? Matter stands closed. Prayers allowed. Matter stands closed to withdrawal. Will liberty as prayed. Otherwise, we're not going to get anywhere.
But it's because the order finally passed is on.
We understand, Mr. Paul. We understand. But I mean, like the records have to be.
Daily list item number 4.
Who's appearing for respondent number? What? Who's not appeared?
Your Lordship, I am waiting for the petitioner.
4 and 5, but
No, where's 4 and 5?
4 and 5.
Mr. Day. You're for 1. 1. 2 and 3 is Mr.
Lordship,
Fly.
I'm the state.
Have they been served 4 and 5? Who's is appearing? Can see on his jawline.
Lordship, is this daily list item 4?
Yes. Have you served item response 4 and 5?
Your Lordship, you will file the affidavit of service, Your Lordship, so we need some time to find that.
Yes. Counsel petitioner submits that praise that you have to file affiliating service within 2 weeks from today. Yes.
4, 5, 6.
Is thereafter.
4, 5, 6.
4, 5,
Your
6.
Lordship. Apply, Your Lordship.
Item 4, 5 and 6 is.
Item 7.
My lord, in this item number 7, my lord, state respondents are from number 3 to 11, my lord. So we have filed one affidavit regarding the calculation which was done by the Water Resource Department, which is respondent number 7. So, my lord, we have also been served the copy of the affidavit filed by the union, NHIDCL. So, my lord, there are some facts.
Who's appearing in NHIDCL?
Mr. Devnath, my lord. So, my lord.
Where's the Devnath? He always plays truant.
My lord, what happened when we go through the affidavit, there are certain things which they are referring, they have contact the Department of Public Health Engineering. So some issues are there. So we have to sort out, my lord. The affidavit of the union, my lord.
Devnath.
No, we are referring to PHE department. So PHE is on a party here. This is number 10. So we need to have some instruction PHE. That's what I'm saying. Because right now we are confined in water resource. We need to clarify that. Because they are saying that this pipeline does not exist.
Where does he say that?
My lord, in certain parts of the affidavit, my lord. My lord, may kindly come to page 7 of the affidavit of the union, my lord.
Yes.
My lord, the first paragraph that's starting in page number 7, my lord, there the NHIDCL is saying that there are no connection of operational GI pipelines.
Where is that?
My lord, may
Which
kindly.
paragraph?
My lord, first paragraph.
Page 7, second
Page
paragraph.
7, second paragraph, during the inspection. Yes, my lord. An abandoned water tank was identified. However, contrary to the petitioner's claim, the inspecting team found no connections of operational associated with the Moushin flow irrigation system. And then, my lord, they have referred that they have a representative from the Public Health Engineering Department. Those issue, my lord. Whereas here, my lord, the water, it refers to irrigational water supply, which is Water Resource Department. So how far Public Health Engineering where inspection was done in the presence, so those issue has to be
verified. Where's the Devnath? Just take down. On the last date of hearing, that is 22/7/2024, no representation was made on behalf of the respondent 1 and 2 NHIDCL. Stop Today also the matter is called up and taken up. There's no representation. Let notice go to the respondent 1 and 2 from the court indicating the fact of non-appearance of their counsels. Just after 1 week, yes.
Obliged.
Item number 8.
Your Worship, in item number 8, I had filed my rejoinder, but the registry had notified some defects. So I require some time to cure the defects.
What defects? What defects?
Type copies?
Not legible.
Yes, some documents are not legible.
Yes, Mr. Paski submits that though rejoinder been filed, as some defects have been pointed out by the registry. He prays allowed how much time?
1 week's time, Your Honor.
1 week's time to correct the same. This is thereafter answer also. Yes.
Item number 9.
9, Your Lordship, will come along with this. It will come along. Obliged, Your Lordship.
Item number 10.
May please, Lordship.
Yes.
Lordship, I pray for some more time to file rejoinder, Your
How many
Lordship.
times you prayed?
This is the second time, Your Lordship.
Rejoinder is not by right. We'll place for hearing. Meanwhile,
Your Lordship, 1 week's time, Your Lordship.
we'll place for hearing. Then meanwhile, if I the rejoinder, okay. Yes. MSGC Maro prays for the allowed further 2 weeks time to file rejoinder. Stop accordingly. This is the matter for hearing for 2 weeks. Rejoinder should be on board by then.
Obliged.
Yes.
11.
May please, Lordship. I'm appearing for respond number 9 to 23, Lordship.
For the
9 to 23.
9 to 23.
Yes, Lordship. Lordship, I'm praying for 2 weeks' time to file my affidavit.
Yeah, MSZ Begum.
Yes.
Yes, for the 2 weeks time as prayed. There's allowed.
Interim order may be continued, Lordship.
Yes.
There is interim order, Lordship.
But let the order pass. Yes. Further 2 weeks time is as prayed allowed to respond on 9 to 23. If I affidavit, interim order pass earlier shall continue to the next date.
Lordship, in item 14 is similar matter, Your Lordship. So that also
Sure,
we,
14.
Lordship, will need further time for filing the affidavit, Your Lordship, item 14.
14 state. You also are there?
I'm not there.
They'll have to take step against a private respondent, Your Lordship. A similar issue, Your Lordship.
Mrigendra Burman.
Lordship, yes.
Number 5 is?
I have taken step, Lordship.
Managing committee, Your Lordship.
You've taken steps?
Yes, Lordship.
Number 5, Officer indicates that service not complete on and respect respond number 5. Petition to obtain status of service done. Next para Emmet Andy should I learn AAG? Praise for on behalf of wonderful prayers allowed.
2 weeks time, Your Lordship.
2 weeks time to file affidavit.
It will come along with that.
This or yes, this together with also.
Lordship. Obliged, Your Lordship. We file now.
Item number 12.
Lordship, this matter involves about dumping of soil into my agricultural land, Lordship.
Where rejoinder? You file?
Yes, Lordship. I have filed.
Ready for hearing?
Lordship. Even today also it can be disposed of, Lordship. Because it is disposed of, Lordship.
Oh, disposed
because
of.
it is covered by the earlier judgment of this honourable court, Lordship, this case. As I have also annexed the earlier judgment along with my
Mr. Shula, you've seen that early
Lordship,
judgment?
yes. That the case, Your Lordship, was pleased to pass the draft. I was there, Your Lordship, for the state.
Disposed of, Lordship.
But I don't know, Your Lordship, whether the union will.
Oh, he's not there. Lordship. Yes, the pleadings are complete. This is matter of hearing after 2 weeks. Yes.
Right.
Yes.
13.
Hello, myself B. Sam from Guwahati. Whenever I see,
Yes.
whenever I see 2 weeks time for final rejoinder matter in this case.
Yes. 3 weeks time as prayed allowed for rejoinder. Yes. Yes.
It's okay, madam.
Agree with you.
Hearing, item 15.
May it please.
Yes. Where's the chair? Yes? All the parties here.
The Lordship has listed this matter, especially
Yes.
Lordship may take this matter at the end of the court because I don't see.
Yes.
They are there for item 17.
So, Your Lordship, the issue in all these matters are common.
Yes.
Issue in all these matters are common.
Yes.
And petitioner is seeking transfer, my lord. Mr. Sengresu is here.
Yes.
My lord, the issues submitted by all the learned members, learned parties, my lord.
What are the common issues that arise in this matter?
My lord, listen, I have also submitted the few issues.
No, from what all are submitted the suggested issues.
My lord.
Yes. You are?
My lordship, can you see the petitioner in transfer petition number 2 of 2019, Yoko Mar, my lord, is the lead case. Number 15, item number 15.
1 second.
Transfer petition number 2.
Yes. Transfer petition number 2.
No, 1 second. One is by Francis Rani S. Walang. One is by H. Long Clau, Don Borembai.
Yes.
Then the respondent is I.O. Yorat. Then you I.O. Kumar Yorat.
My lord, I'm
okay. This is yours.
Yes.
This.
My lord.
Okay. Then S.D. is here.
He's here. I saw him. He's come.
Tu Borlang. Then B. Rap Sang for Hame Banshambor. Here. Yes. Right. Okay.
All the parties.
Start.
My lord. So if I request my lord to see the suggested issues forwarded by my side, from my side.
Also, just let me get the notifications to one side. Oh, you arrange in chronological order. Just arrange the notifications chronological order. I too. Are you know? Are you in it? Yes.
My lord, the issues, my lord, I have submitted 5 issues derived from the record.
This is yours is
my lord.
TRP number 2.
Yes, number 2, my lord, 2019.
Yes.
Well,
HL Chowri. So. Arrange an order. 11, 18, 15 on ideas. Yes.
Well,
yes.
So issue number 1, my lord. After that, I'll invite lordship attention to issues framed by learned HE.
Yes.
As to whether the judgment and order dated such passed by the learned division bench in the case of Kumarjan Singh such in ignorance and or in contrary to the judgment and order 2020 passed by the Honorable Supreme Court in the case of Malvin Mount is a judgment per incurium and therefore not binding to the single bench of this Honorable Court. Number two, my Lord, as to whether the judgment order date 2020 passed by the Honorable Supreme Court in Malvin case is binding to this Honorable Court under Article 142 of the Constitution of India, even if assuming that the judgment and order dated passed by the division bench is not per incurium. Another is as to whether the notification dated such issued by the governor under rules and such, my Lord, 1937.
Notification 3 okay.
Yes, is automatically denoted the power of designated officers of the District Council Court from trying offences as per notification dated such. So 2017 is a notification conferring power to District Council Court. Right. And other is as to whether the notification 2022 issued by the governor extension of CRPC to the courts in the state of Meghalaya amounts to automatically strip off the powers of the designated officers of the District Council, confer void notifications and such, despite of the fact that they are conferment under paragraph 5.1 of the 6th schedule still subsists. And one is, my Lord, as to whether the state respondent can rely on the saving clause mentioned in the notification dates and such issued by the governor, despite of the fact that there is no source of power for the governor under proviso to subsection. This I derive from the affidavit filed by the attorney.
So you stop here. Now all the councils in agreement with these issues, or you have any additional issue to be taken up? First is this, whether the commercial judgment.
Yes.
Yes.
I have one submission to make.
Yes.
What my friend is in essence is arguing before you lordship that the commercial judgment is not binding.
It's per incurium, yes.
Yes, what he's saying that the judgment is per incurium.
Yes.
So and my, if your lordship can you see my issue? My issue is what I am saying is that the
No,
judgment.
we'll look at that first. We'll look at the petitions issues.
No, I'm just in order to confirm the clutter, my lord. The clutter is that whether the judgment of commercial is settles the issue or not. And if yes, if it settles the issue, then whether this court can declare the judgment of division bench per incurium, or whether that judgment of division bench is not binding on the single judge. Whether the single judge can say that division bench order is not binding because it is per incurium. First, my lord, my friend has to establish on the fact that the judgment is not binding.
Right.
Yes.
Then you also can go. Then you also can go into the issue whether it is per incurium or not. First, my friend has to show from the judgment why the judgment is not binding, or why, and if that judgment is not binding, whether the judgment cannot be followed on the ground that it is per incurium. What my friend is saying, please do not follow the judgment of the division bench because it is per incurium.
Yes.
That's a proposition of law which my friend is trying to establish through all these.
Yeah, no, you have to show one thing. First thing, why it is not binding by distinguishing. That's all.
Yes.
But only thing is that distinguishing. Right. If you can't distinguish, then we are bound.
My lord, there is one issue.
Yeah.
My first issue is that the division bench is per incurium. If I establish, there's one matter issue. Second issue is, even if it is not per incurium, the division bench order is contrary to the law laid down by the apex court in the Malvin case.
But sitting single bench, isn't this court bound by the judgment of the division bench?
My lord, because the Supreme Court order is
we have that liberty to, to break judicial discipline?
But according to my humble submission, my lord, it will not.
Otherwise, it has to be referred to a division bench again.
That is one option. That is, my lord, that option
Otherwise,
is there.
It will have to be done like that, Mr. Advocate General, because that is the only thing.
Yes.
If what is seeking to establish, and I think we wasted enough time then in single bench.
And Supreme Court judgment is very clear. Supreme Court judgment is very clear.
We can't sit, this court is not sitting the appeal over the judgment of division bench, correct?
That is true,
you see, we are not going to examine it in that extent, that to say that whether the judgment is wrong or right. Only thing is that the only limited, whatever jurisdiction we can exercise to see how we can distinguish it. That from the facts of your case, that judgment will not be applicable, though might be applicable in other situations.
Yes.
What do you say, Mr.
I would submit that now there are two judgments. There are two judgments, rightly or wrongly. One is the Supreme Court and one is the division bench. Now the question this court will have to answer is whether this court is bound by the Supreme Court judgment or by the division bench.
You're bound by both.
So
what we're going to do?
So that is the issue. Yeah. No, because my lord, very.
Is not what my friend is saying. The Supreme Court judgment is contrary to the judgment of Contempt is also not correct, my lord.
That is on the merits of the case. We will
I
argue.
will have a problem also because if I remember correctly, one of the sitting judges here appeared also for the state, I think. Correct?
What?
One of the sitting judges appeared for the state also in this matter.
In this matter?
And if it go division bench, then one brother judge was part of the division bench.
Is also.
Oh yes, we can have another bench.
What I am submitting, your lordship will not. That stage has not come where your lordship will.
No, but that
bench is
the
available.
stage has not come, but the possibility has arisen.
Possibility has arisen.
And possibility has arisen, and if we travel down the road and we hear the matter for 3-4 days and decide that yes.
What has happened, my lord? Only if your lordship kindly give me half an hour, and if I am able to satisfy your lordship that in half an hour it is covered by the commercial, it is covered by Supreme Court judgment, because what is happening, my lord, that trials have come to grinding order. For example, my lord, out of 15 witnesses, 11 witnesses have already been examined in the first matter, my lord, by the regular session court in Meghalaya. And there is still, my lord, and if I can just see commercial and my friends.
Are you agreeable to let Advocate General place his case?
My lord, we have since we have the petitioner, we have the right to address. My lord,
he's not agreeable to that.
This is my lord, we learn from Lord Shivin.
He's like you say, he owns the place.
My lord, the government has passed the notification. There are two parts to the notification. My lord, we'll just come to paragraph 37 of the commercial case.
I will answer everything.
I will just come to
on my turn, my lord.
paragraph 37 of commercial case. My lord, it's got paragraph 37. Since no irregularity, far less any illegality has been found in the conduct of criminal trials, as in the present case, the validation of the trial conducted in this case need not be on the crutches of the second paragraph in the relevant notification 2022. Though it is not necessary to look into the basis for including the second paragraph in the said notification, prima facie it appears to be by way of abundant caution. At any rate, the justification or efficacy of the relevant paragraph may be more appropriately assessed when it is pressed into service. In the present context, it is wholly immaterial. So what the division bench has done, it has failed to look into the second part of the paragraph of the notification.
That says that the power is not denuded. What is the second part of the paragraph? Of the 22 notification?
Of the 22 notification.
Yes.
So the division bench has not touched on the second part of the.
I'm sorry for interrupting, my lord. There is now notification by which BNSS has also been notified, my lord.
Where is that?
Yes, I have that also. I have this one. This is the same.
BNSS, my friend, I am going to my friend. Here.
My lord can have a look at this, the last notification. So even as per the last notification, my lord, the last paragraph, the District Council courts shall continue to derive powers under paragraph 4 and 5 of the 6th schedule of the Constitution of India. Now this paragraph has not been addressed by the division bench. He said it's not material.
I made observation with regard to this 4 and 5 in the another case yet appeared with regard to that inter-district subject.
Yes, my lord. That was in civil.
Yes, that's in civil, of course, but then
civil,
the
same
of powers
principle
is still that the powers are still with the District Council.
With the District Council in view of paragraph 4 and 5.
Power in the Constitution cannot be taken away by notification.
No, what I'm trying to say before we go further is that the division bench has not. The division bench has not addressed the second paragraph.
We have to examine what powers.
No. What he's trying to say, is that the commercial judgment has not addressed the second paragraph of the notification of September 20th, 2022.
Yes.
Yes.
So that is still open for this court. That is still open for this court to interpret.
Let them start, yes.
That is my.
Let them have the first innings. Let them. Yes. The batting or bowling, I don't know, but yes.
So there is no bar for this court, even sitting as a single judge, to look into this aspect of the matter.
That's what distinguish,
yes.
You mean?
Yes.
Yes. Okay. Yes.
My Lord, may I come to the division bench order, my Lord?
Yes.
The Kumarjan case. Now, we place, my Lord, the division bench was very much aware of the contention between the two parties, referring to the, my Lord, Solemn judgment also. And when we move this petition also, the learned division bench has recorded, my Lord, we just submit the order passed by the division bench in the Kumarjan case. In the Kumarjan case.
I have the order with
my Lord, the earlier order where, my Lord, Solemn case was referred. My Lord, para number 3, may I take, my Lord? Learned Counsel for the appellant, relying upon the notification such 2007 issued by the Governor, submitted that since the victim and the accused are tribal, the learned session judge, Deputy Commissioner Ripoi did not have jurisdiction to try the case. Learned Counsel for the appellant, in support of his submission, relied upon the decision of the apex court and such. Mr. Sansat Learned AG, on the contrary, relied upon another notification, 3rd May 2018, issued by the Governor, in exercise of the powers conferred under such 1937, and further subsection 1960 as adapted, read with para 5 of the 6th Schedule Constitution in there, and submitted that Governor has also conferred similar powers on the district and session judge Ripoi for trial of all offences punishable with death, imprisonment for libel, or term exceeding 5 years under the Penal Code. Learned AG further submits that if the powers are conferred by the Governor on both, namely the District Council Court as well as the regular court, then naturally the regular court has a jurisdiction. That is his submission. Learned Counsel for the appellant needs some time to go through the notification relied upon by the Learned AG. We also have the opinion that the issue involved in the appeal is having large repercussions. The debatable points have also been raised by the respective councils. The issue requires early resolution. Fix this matter. So the argument advanced by the state in that case is that they relied on the notification with regard to the Ripoi district. He never argued that in view
So you mean that the list was confined to
Ripoi district.
Examination of the notification of Ripoi district?
Ripoi district only. All throughout. He did not even produce the notification with regard to East Khasias.
So there means deliberations only with that two things.
Exactly. And all this transfer here, in my case, was the Yokumar, is from the East Khasias.
Okay.
My Lord, this was another bench we argued, and subsequently the other bench which delivered the final judgment, the same judgment, Solemn judgment was referred. However, the Learned Division bench expressed that no, it is not relevant to the preceding case. So the court declined to examine the Solemn judgment. Now, therefore, my humble submission is that the judgment delivered in the the Kumarjan is purely confined to the notification issued for the Ripoi district.
Okay.
Ripoi district.
So the judgment is confined to that?
Yes, confined to that. Therefore, it is distinguishable for other districts.
Okay.
And when we look the final judgment, the judgment of the Kumarjan, my Lord, may I come to the operative portion. Paragraph 31. Paragraph 31. Onwards, may I take Lordship attention?
Yes.
There is no basis to appellant's contention that once the authority in terms of paragraph 6.1 of the 6th Schedule Constitution is conferred on a court on an officer, the governor has no residuary power to carve out a part of the authority already conferred and vest the same in some other court officer. Indeed, reading such a limitation would defy logic and would be an anathema to the efficient.
Where did it from?
Paragraph, my lord, 31 of the.
There's no basis the appellant's contention that one's authority in terms of paragraph 5 is conferred, also the governor's covered part of the authority or conferred because the same.
The governor has no residuary power to carve out a part of the authority already conferred and vest the same in some other court or officer. Indeed, reading with such a limitation would defy logic and would be an anathema to the efficient justice delivery system. For example, in a particular matter, the judge manning the designated court or the named officer conferred to authority may desire to be recused. If the argument put forward by the appellant were to be accepted, that would imply that the particular matter could not be assigned to any other court or officer, and that would go against the grain of paragraph 6 statute. It cannot be said that authority to assign a particular matter to another remains in some situations, and such authority is not generally available unless the governing provisions specify as such. If there is the authority to assign a particular matter to another person of forum, it must be that there is general authority to carve out a portion of the office to another with the same. Now, therefore, my lord, here, though I cannot argue against the judgment of this very judgment, but the learned division bench misconstrued the argument of the petitioner there. We never say that once conferment is given to one officer, governor cannot invoke this section.
No, I think just one second. You know, the thing is that Mr. Chandra, I think you're alive to the fact that this conferment of powers for offences over 7 years, transportation for life or whatever, is by person. It's called persona designata, and the governor confers power by name. As done to the council all the time, not by designation.
Not by designation.
In fact, my lord, after the judgment of Commercian also, the new judge and the additional
by
judge
name.
Have been conferred by name.
Yes.
They conferred by name.
By name.
So that assumes some importance with regard to this observation. Now, suppose Mr. X has been conferred the power, right?
Yes.
And then Mr. X recuses.
Right.
So what will happen then?
Now,
doesn't mean that residual, like if that the appellant will be left or the accused will be left without the remedy.
Governor has the power. Because of that, to overcome those situations, governor always confer to 2-3 designated persons in name in district council court also.
No, before this, you asked the Dingdo, before there's only one. For a long
earlier
time.
one,
Yes.
Earlier one,
Only one judge.
But when we argued the case, two judges were under conformity.
Now there are 3.
Now three. So to overcome that one, if particular judge A recuses himself or herself, another judge can try. So to overcome that situation, governor has conferred to 2-3 officers in by name.
Okay.
So
yes,
we don't have dispute with that.
Yes.
But our dispute is that once we confer to a particular officer by name, whatever, that conferment operates in entire territory of the Khasila, the Autonomous Council. Governor cannot lift it without revoking that one and give it to one particular officer for one particular district. That district is Ripoy district. That was a debate between the petitioner and the respondent state before the division bench. Confined to this Ripoy district. So if I travel further, my relevant portion.
Now, my lord, if I intervene now in July,
there's no
conferment of power.
So all the matters go to the regular sessions court.
So the larger issue is that, my lord, in this case, the larger issue is that whether the district council exclusive power or the district and session judge can also take up these matters. I think that is the larger issue.
Yes. No, whether you can go to, suppose, like what's happened with succession. Okay, under in Succession Act also, then the judge, the council court invested with powers also. So also the other courts here. So what happens? You get a succession certificate from there, and then will that be invalid, or do you get it from here be invalid?
My lord,
used to tribals.
My lord, my humble submission is, my lord, the conferment given to the district council under para 5A is exclusively between the parties tribal.
It has happened where they've come for that time before the separation of powers for deputy commissioner and obtain succession certificates between tribals. because they have invested with powers as in Succession Act.
Therefore, my lord,
it's not a question of of saying that only one tribal or another non-tribal. No, it's a what do you call it? General power given. And we've had cases where one wife obtained from there, another wife has gone for the council.
That's the situation. My lord, therefore, when we look this issue, my lord, according to me, my lord, we have to examine this aspect from the point of view of the sixth schedule arrangement.
I'm in agreement with the Advocate General. We said that first the parameters of this entire hearing that we'll have, you should keep in mind what are the limits of power that single bench has in relation to the division bench order that's already there.
Well, I've just been informed. In fact, the District Council are in the process of challenging Commercial case before the Supreme Court.
Yes, but I think it's a bit late. Now SLP
a bit late because the District Council was never a party also in that in that case, because this is more of the academic. The District Council have just been informed. I asked my friend to make a call.
Has it been filed?
That's what they said. Whether they'll come up or not. No, I'm just informing this court because later on they may say that you never informed the court that you've gone.
Who's doing it? Mr. Vijay Hansaria?
I think Mr. Hansaria is on the... I had advice.
You'll know better, Mr. Arfaji, you know better, he's your senior.
In fact, I advised them a long time ago.
I am challenging your decision, but the client did not come back to him again.
Yes. So are we going somewhere the hearing, or we just,
If you want to permit me, I can summarize the issue, my lord, and then my friend can, because my friend is saying that commercial is not binding, if I have understood correctly.
Yes, yes. Lordship, can you see paragraph 34 of the Commercial judgment?
Yes.
However, in view of the second paragraphs in both the notifications of December 10, 15 and May 2018.
1 second.
The earlier notifications pertaining to trial of para 34.
How do you do the second paragraph of the board notification? December 10th, 2015. Second paragraph says,
but it is superseding, my lord. It supersedes the earlier notification. So,
no second.
But however, in view of the second paragraphs in both the notifications of December 10, 2015 and May 3, 2018, the earlier notification pertaining to trial of serious crimes within the Ripoy district stands superseded, and the power previously conferred to the District Council Court or particular officers can no longer be exercised to the extent that it has been superseded. So, court has the impression that prior to this conferment in Ripoy district, the conferment given to District Council governed the entire territory of the District Council. But since these two notifications say that the earlier notification is superseded, so the distribution bench read that the conferment given to District Council officer is superseded by this latest 2015 and 18 conferments, and therefore District Council, the Session Court, as a additional Deputy Commissioner in Ripoy District, has the power to try the cases. That was the reading. In fact,
so even
that was
patently erroneous. Yes. But then what can the court do about it?
I cannot challenge.
I understand what you're submitting. That this supersession only that was conferred on a certain judicial officer, then superseded on all the additional deputy commissioners, who are posted in, under the regular judiciary in Nongpo, Ripoy. But does not touch at all the other general notification issued by conferred a power by the governor on the District Council Court, which exercises powers over entire Khasi Hills.
Right. Correct.
Yes.
But therefore, in that, my lord, reading of this judgment, it never says that, my lord,
it becomes more and more difficult than
therefore, my lord,
if the basis of your entire arguments we understand, it's like being helped. Hands are tied. This court's hands are tied.
Therefore, my lord, I'm saying that that the Commercial judgment is only confined to Ripoy district. It never held that this apply to all the
Okay, just off
council
the
areas.
record, do you think commercial judgment is right or wrong?
My lord,
Off the record.
in fact, with due respect, my lord, this is one of the most confused judgments we come across. With due respect, my lord.
Yes.
The real issue was never addressed in that case. My lord. But since, however, my party unable to challenge, my lord, I cannot assail the legality of
But
this
you were
case.
the leading counsel there.
No, in fact, my lord, I had assisted my friend there and had cited Solang Peo case also. Our learned Chief Justice then said, no, it's a wrong judgment. So then I sat down.
My lord, it's not correct, my lord. With great respect, my lord, we can say anything, my lord. Let me read commercial judgment, my lord. They are reading excerpt of one paragraph here and there. And that is why...
Wait, I can do with due respect to another AG.
Okay,
I can.
okay. Let the AG is very edgy. So let them do some question.
We can read the entire
Yes, okay. Let's hear you. Yes, we'll hear you for half an hour. Yes.
Then we'll reply.
Yes.
Kindly see commercial judgment, my lord.
Yes.
But see, my humble submission issue which calls for a lordship kind consideration is this: whether the regular session court in Meghalaya has the power to try the cases between two tribals where the offence is punishable with sentence of more than 5 years. If I am able to demonstrate, my lord, that they have the power to try the cases, my lord,
yes,
then the question of transfer will not arise. Why, my lord? Because the transfer will arise. The main plank of the argument of my friend is that regular session court has no jurisdiction in Meghalaya to try the cases. My friend has brought to your lordship kind notice 3 things. That in Garo Hills we do not have the district council, there is no conformity. In Jandia Hills also there is no conformity.
Yes.
There is a conformity with regard to Khasi Hills Autonomous District Council.
Yes.
Now the question is called for your lordship kind consideration is this: whether the regular district court in Meghalaya has the power to try the cases between two tribals where offence is punishable with sentence of more than 5 years. That is the if the session court has the power, then they cannot seek transfer from session court to the district council court. So first thing which in my humble submission, which the petitioner is required to show to your lordship is whether the power of regular district court has been denuded in view of the notification, or they are, because if the argument is, my lord, that a regular district court, session court in Meghalaya, in Garo Hills, in Jandia Hills, they have the power. But so far as Khasi Hills are concerned, if district council area of Khasi Hills are concerned, they do not have power.
No, see, that comes from paragraph 4, where the district council have been invested with powers to constitute courts to try offences between tribals. And then you look at the judgment which is so that means if an FIR is lodged in regard to a dispute or some conflict between tribal, then it goes to the district council courts. So that judgment is there. Plus we're going by constitutional mandate. The thing is that what they are standing on constitutional mandate, no one's questioning the authority of the district sessions, regular district sessions judge to try the matter and say that power given by constitution to the district council courts can be taken away. That's all. Yes.
Yes, my lord. I'm grateful, my lord.
Yes.
Of this observation. Your lordship has referred to paragraph 4.
Yes.
Paragraph 4. Now, paragraph 4, power cannot be taken away. The regular district and session court cannot try the cases where paragraph 4 applies.
Yes.
Kindly record my submission because paragraph 4 is absolute embargo, absolute prohibition. So therefore, the question which will arise for your lordship consideration is cases which are falling in paragraph 5, not in paragraph 4, because paragraph 4 is the cases where the sentence is up to below 5 years. And in all these cases, offences are of murder and rape. So they are all falling under the paragraph 5. So issue exclusively for your lordship kind consideration is paragraph 5, not paragraph 4.
Okay, not paragraph 4.
Yes. There is no transfer of paragraph 4, my lord. There is no case, because in paragraph 4 I would have conceded that in paragraph 4 the regular district session court in Meghalaya has no jurisdiction to try the cases between two tribals, my lord.
Yes.
When paragraph 4 applies. That there is no confusion, my lord, so far as paragraph 4 is concerned.
That's all right. Then we are clear. Okay.
Yes, my lord. All these cases relate to paragraph 5.
I mean all 302 matters. They all 302 matters. All
302 rape, all 5 years. 5 years more.
376, different sections are there.
But all over 7 years.
All over 7 years. Beyond 5 years punishment.
More than 5 years.
Okay.
So then paragraph 4 does not apply, with respect
Okay,
to... So
right then. That makes it clear, fine. Okay, that makes it clear.
Yes.
Okay, yes.
Yes, kindly now in the first, Your Lordship, I would have preferred to show Your Lordship provision, but my friend has read so much about the commercial. Kindly see paragraph 2 of commercial first, Lord, so that the issue will get clear.
Yes.
Paragraph 2. As a result of this frontal challenge to the authority of district and session judge to take up criminal trials where the victim and accused are tribal belonging to the same tribal area, subsequent appellant have jumped on the bandwagon, if only to delay the inevitable or hope better weather on the bench. The speedy disposal of criminal appeals in this court has been affected as a consequence over the last 6 months or so. For one or the other reason, the search of relevant notification published under the authority of governor of the state, a speedy disposal of the appeal was impeded. Before coming to the nature of paragraph 3, objection taken by appellant as to jurisdiction of the trial court in this case, a special feature of the state must be adverted to. Except for a small pocket in capital city of state, which area is known as European ward in Shillong, the rest of the state is regarded as tribal land. Khasi and Jantia tribes occupy the central and eastern part of the state, while the western part is in the land of Garo tribes. Accordingly, there are 3 distinct autonomous health councils. The autonomy of district council and an independent court structure under them is provided for the 6th schedule to the Constitution of India. The 6th schedule to the Constitution of India was designed on the basis of recommendation of Gopinath Bordoloi Committee set up by Constituent Assembly. Discussions in course of Constituent Assembly debates reveal the history from the British times when some regions in northeast were described as backward areas and others as partly backward areas. That Monte-Chemford report later criticized less offensively as excluded areas and partly excluded areas. In essence, the 6th schedule mandates that tribes would be governed by their law, custom and usage, and disputes between them would also be resolved by village elders, of course, set up by the tribal council, except in certain cases of matters. Indeed, for the present purpose, paragraph 4 and 5 of 6th schedule to the Constitution of India of some villages. For the present discussion, paragraph 4.1 and 5.1, 5.2 and 5.3 of 6th schedule may be noticed, Lord, that kindly see. Please, the Regional Council for an Autonomous Region, in respect of your Lordship, will see the Regional Council for an Autonomous Region, in respect of areas within such region, and District Council for an Autonomous District, in respect of areas within the district, other than those which are under the authority of Regional Council, if any, within the district, may constitute village council or court for the trial of suits and cases between the parties, all of whom belong to scheduled tribe within such area. Other than suits and cases to which provisions of subparagraph 5.1 of this schedule apply, my lord. So kindly mark these lines, my lord. Other than suits and cases to which provisions of subparagraph 1 of 5 apply. So 4 says, my lord, that if the 4 is saying, my lord, that if 5 applies, then 4 will not kick in, my lord. So if 5 is creating exclusion clause, my lord. Now kindly see.
Yes.
The conferment of power under Code of Civil Procedure and Code of Criminal Procedure on the regional and district council and on certain courts and offices for trial of certain suits and cases and offences, my lord. Now I have one submission to make, my lord. My reading of paragraph 5 is that there is no even a reading of paragraph 5, my lord, there is no restriction for even district council to try the cases between tribal or non-tribal. Because 4 exclusively talks about between 2 tribal. But 5 says, my lord, that it can be, the conformity is there, then it can be tried. But you also will see, in that context, the governor may, for the trial of suits or cases arising out of any law enforced in autonomous district or region, being a law specified in that behalf by the governor, or for trial of offences punishable with death, transportation for life, or imprisonment for term not less than 5 years under the Indian Penal Code or any other law or time within force applicable to such district or region, confer on district council or regional council having authority of such district or region or courts constituted by such district or any officer appointed in that behalf such power of CPC and CRPC, my lord. If you also will see, there is no use of expression between tribals insofar as paragraph 5.1 is concerned. And in 4, you also will mark there is a use of expression with.
Can we read that into the? Can you read into this into paragraph 5? Okay, no, just digressing, right. Okay,
Your lordship is right. All along 4.1 has been read into 5.1.
Yes.
To that extent, my lord, because but 5.1 is saying that 5.1 is saying, my lord, that the conformment can be given on district council court to try the cases offences punishable with death, transportation for life, or imprisonment of term not less than 5 years. So this power, my lord, district council court is getting by way of conferment.
Yes.
Your lordship may kindly note this, that this power is not vested with them.
It's conferred.
With conferred power. It is if the conformment is there, then they will get the power. If there is no conformment, they will not get the power. So far as paragraph 5 is concerned, under the constitutional scheme, my lord, the district council court has no inherent right to try the cases where the offence is punishable with death sentence, imprisonment for life, or not less than 5 years. So conferred power is there, my lord. Now the conformment. So therefore, if I take the first argument that there is an exclusive right of district council to try the cases, my lord, where the sentence is more than 5 years, my lord, or offence is punishable with sentence of more than 5 years. My submission, my lord, is that there is no exclusivity attached in paragraph 5, my lord. Paragraph 4, yes, it is exclusive power. Nobody can take away the power, and that is what the second line of paragraph 4 and 5. Because there was some apprehension in the mind of people that by notification the power under 5 is also being taken up. If there is a need or occasion to confer the power, that will be done. But that will not denude the power which is already vested in regular district session court to try the cases under CRPC or BNSS now. Or under earlier, my lord, your lordship is fully aware that before the district council came in, in 1937, there is a rule for administration of justice in Jantia Hills and Khasi Hills, my lord, under 1937 rule. Under those rules, your lordship will, those rules, my lord, rules have been under the 1896 Scheduled District Act, my lord. These rules have been framed in 1937.
Yes.
Under the rules, deputy commissioners have been conferred. Deputy commissioners were designated as the judges, and they were conferred to try the cases under those rules, my lord, between the tribals also. Then, my lord, the district council court came, my lord, and then the district council came, and district council framed the regulation qua paragraph 4, my lord. Because paragraph 4 is in the exclusive domain of district council, your lordship, I will take your lordship to paragraph 4. So, as paragraph 5 is concerned, my lord, in the first line itself of paragraph 5, it says, my lord, conferment of power under Code of Civil Procedure and Code of Criminal Procedure. So power of CRPC and CPC are being conferred on district council court, my lord. It is the conferment of, because what is being argued that CRPC was not notified. My submission is that the paragraph 5 itself says, my lord, that power of CPC and CRPC will be conferred on the district council court, and those conferment entail extension of CPC and CRPC, because conformment of CPC and CRPC the conformment cannot take place in absence of extension of CPC and CRPC. So under the constitutional scheme, my lord, it was done. And kindly see 5.2, my lord, on next page, my lord.
Yes.
In fact, first line, my lord, officers appointed in that behalf by the governor, such power under the Code of Civil Procedure or as the case may be, Code of Criminal Procedure as he deems is vested in paragraph 4 where the offence is punishable with less than 5 years. Now, kindly see 2 where the offence is punishable with less than 5 years. Now, kindly see 2 draw or modify any of the powers conferred on a district council, regional council or officer under sub-paragraph at 1 of paragraph. So if whatever power has been conferred by notification on district council, that can be modified, can be withdrawn, or can be altered. So there is no exclusive, this part the sub-paragraph of paragraph 5 further clarifies the legal position, my lord, that this, if the notification under BNSS is issued, my lord, it will deem to limit the power of district council to try the case. My first submission is that there is no exclusive power. Secondly, the BNSS or CRPC has been notified, my lord. Those notifications are conferring power on district and session just to try the cases, my lord. Those powers, because what my friend has to show, my lord, is that the district and session court has no power to try the cases. Then only the district council court, because some notification has been issued earlier or now, my lord. Because I take it, my lord, I take it the submission of my friend is correct, that the notification is there. There is some conferment also by name or by post also, my lord. But there is a conferment on regular district and session court also, my lord. Now, if that is the situation, my lord, whether the question which calls for a lordship consideration is whether the power of district and session court has been denuded because there is some notification, my lord. Because be it under CRPC or BNSS, the district and session judges are deriving their power to try the cases, session trial, my lord. Their power is limited to paragraph 4, my lord. They cannot, in paragraph 4, the regular district and session court, CRPC notification or BNS notification cannot supersede the constitutional provision. There is no doubt about it. There is no doubt about it. So, and this is provided. So then, therefore, there is a saving clause to that extent. Now, my lord, paragraph 6 of commercial judgment, because commercial judgment, my lord, refers to the relevant district, the constitutional provision. There is no regional council in the state of Meghalaya. As aforesaid, there are 3 district councils covering the 3 separate tribes inhabiting the state. Loosely speaking, the area covered by state was under the original Bengal presidency, thereafter province of Assam under the British rule, and ultimately a part of the state of Assam in independent India before the Meghalaya was carved out in 1972. Since 1972, several of the original districts have been bifurcated and further subdivided, and there are 12 administrative districts in the state, my lord. I must say, my lord, the lawyers have been saying that this is a confused judgment, this is that judgment, but with greatest respect, my lord, the division bench has taken a lot of pain, and we have been asked to argue continuously for about 10 to 15 days, and everything was placed, my lord. And then thereafter, because the judgment, if I read, my lord, it will show that each and every aspect has been considered, my lord. And I'm really at pain to say that we cannot say all these things, that we may not agree with the judgment. We do not agree with the judgment. But we have to maintain the decorum and respect, my lord. That is my humble conclusion, paragraph 7. And we, as a council, we do not agree so many times. But the sanctity and the system has to be maintained.
No, that remark came on the query of the court.
Yes, my lord, but that
Off the record.
But we are also victim at times, but we know, my lord, because we have to be, that we have. At the same time, paragraph 7, my lord, the constitution came into effect with the 6th schedule therein. Paragraph 5 thereof provided that neither the code of civil procedure would apply except as previously provided in such provision. In paragraph 5.1 of the 6th schedule of the constitution, governor is permitted to confer such power under either code as he deems appropriate. However, prior to the Constitution and the 6th schedule, therein coming into effect, the previous law in place, including particularly rule for admission of justice of police in Khasi Jantia, 1937, provided that in criminal matters, only the spirit of criminal procedure code was to apply and not the letter thereof. It must be recorded in the state that the history of the administration of justice in as much as the same in the Garo Hills, but since matters emanate from Khasi and Jantia, there is no further reference to the Garo Hills therein. The said rule 1937 was notified by Governor of the then Assam province under Section 6 of Civil District Act 1874, and such rules were to apply to the whole of United Khasi Hills and Jantia district, excluding the areas which were known as Khasi State. However, days before the Constitution came into force in its entirety, Khasi CMC Administration Order 1950 was issued on January 25, 1950. Such order of 1950 brought within its fold the area in the United Khasi and Jantia Hills district covered by 1937 rules and other Khasi states. Though the 1937 rules no longer in vogue, the Supreme Court judgment in 1963 SCR, Nagaland versus Ratan Singh, has recognized for the sake of continuity State rules continue to have effect. Indeed, upon the state being incorporated by Meghalaya Act 6 of 1972, the 1937 rules have been adopted with effect from February 22, 1972. For the purpose of present discussion, it would be suffice to notice that under Rule 1A of Rule 1937, Governor had the authority to appoint additional deputy commissioner, either generally or for trial of particular case or cases pertaining to both civil and criminal matters, and for such purpose, the additional deputy commissioner would exercise all or any of the powers of deputy commissioner. In due course, the deputy commissioners elsewhere in the country came to be recognized as collectors, now mostly known as district magistrates, but in idyllic state in lap of nature, striding the custom continues of deputy commissioner heading the district. Rule 16 of State Rule of 1937 stipulated that criminal justice shall ordinarily be administered by deputy commissioner, his assistant, by Sardar, Doris and other chief authorities of the different communities. However, in terms of Rule 17 of State Rules of 1937, only deputy commissioner had the authority to pass a sentence of death, transportation or imprisonment up to maximum amount provided for offence and the like. The more serious sentence of death, transportation in 7 years or more were subjected to confirmation by the High Court of Assam. Petty cases were to be taken by Sardar, Dolois and other chief authorities as would be empowered by the deputy commissioner. An appeal would lie to the deputy commissioner from any decision of the assistant. It appears the word assistant in the appeal provision in Rule 21 covers Sardar, Dolois and other chief authorities in addition to special provision that the deputy commissioner could appoint for taking up petty matters. As to the application of criminal procedure code, Rule 23 of the state 1937 recorded that deputy commissioner and his assistant shall be guided by the spirit of code of criminal procedure as far as it is applicable to circumstances of district and consistent with the rule. Order of 1950 covered as indicated both United Khasi and Gentiles and also Khasi state except municipality of Shillong and cantonment. Such order of 1950 recognizes Khasi CMC, where the CM means a customary head of Khasi trial institution, often administrative area of United Khasi and Gentiles district known as Khasi state. State order of 1950 provided for administration of criminal justice to be by the deputy commissioner or additional deputy commissioner and his assistant, and also by courts of CM. Rule 3 of State Rules of 1950 extended the Indian Penal Code to the extent it was applicable to other areas of state of Assam. Rule 16 of State Order of 1950 defined code of CMC and jurisdictional sub Rule 2 mandated that code of CM may try offences under the Indian Penal Code or any other law for time being enforced except those punishable with death, transportation or involving a punishment of 5 years in imprisonment which may arise within the limit of locality and which Khasis who reside or hold land within its locality are concerned. For completeness, it must be recorded that United Khasi and Gentiles Autonomous District Administration Rule 1953 came into effect for the entirety of Khasi Hills Autonomous District, including the areas comprised within the municipal area of cantonment. Rule 4 delineated the class of courts with villages court at bottom of the pyramid, subordinate district council court and additional subordinate council court in middle of 3-tier system, and district council court and additional district council being held. Rule 9 of the rules contemplate a solitary district court, council court for Khasi Autonomous District Council in dealing with powers of the court. Village courts were not made competent to try offences, etc., which were obligatory under the penal code, as the village code has no authority to pass sentence of imprisonment or the upper limit of fine, as it could fix has since been enhanced to 150. In respect of criminal matters, subordinate district council court is given authority under 1950 rules to try all criminal cases not triable by a village court in which offence is committed within jurisdiction. The additional subordinate district council court are competent to try all criminal cases not tried by village court in which the offence is committed within the jurisdiction. Some exceptions are made as to which such authority in specific instances. The only other provision is to know is the Rule 58 of Rule 1953, State Order of 1950 stood repealed. So several other set of rules have been referred to in passing in the course of hearing. The only other body of rules that may be specifically noticed would be Meghalaya Judicial Service Rules 2006 Schedule A, to such rules to post by the name of district and session judge. Qualifications for such posts are identical to those necessary for district and session judge elsewhere in the country. According to the appellate, the authority under paragraph 5(1) of 6 to the Constitution has been conferred, has been exercised by government in the state of Assam, where Meghalaya was also an integral part of such a state, and by subsequent notification after formation of state of Meghalaya. Parties have brought several notifications bear on the issue, beginning from one published in February 27, 1989, by which name a judge of Khasi District Council was vested by the governor with the power for trial of offences punishable with death, transportation for life, or imprisonment for term not less than 5 years under the Indian Penal Code or any other law for time being applicable to Khasi Autonomous District. A similar notification followed on November 20, 1989 by which additional judge of District Council Court in Khasi Autonomous was similarly empowered. My Lord, kindly pause here for a moment. My friend has said that only notification relating to revolt was referred. That was incorrect. Kindly see. All notification, a further similar notification came to be issued on April 21, 2006 with named judge of Khasi Autonomous District Council and being similarly ordered. On April 21, 2006, another additional judge of the Khasi Autonomous District Council was also given similar. On March 19, 2007, again exercise of March 29, 2007, again exercise of the governor's authority under paragraphs 5(1) of 6 schedule to the Constitution, and magistrate in the Khasi Autonomous District Council was conferred with the power of the judicial magistrate. First class as provided in Code of 1923 for trial of offences under penal code or under any other law for time being applicable in the Khasi Autonomous District Council. On August 11, notification was issued by under the order of governor approved the appointment of the named judge of District Council Court, Ceylon, to try the offences punishable with death, transportation for life, or imprisonment for term not less than 5 years under the Indian Penal Code or any law for time being applicable to Khasi Autonomous District Council. However, within short time thereafter, September 28, 2003, the judicial officer in the regular hierarchy of the judiciary, not from District Council Court structure, were vested with the power of judicial magistrate, first class as defined in Code of 1973 within a specified area. Such notification of September 28, 2011 specified that notification was in supersession of earlier notification in respect of same matter within the Khasi district. However, the notification of September 28, 2011 referred to Rules 1937 and said order of 1950 and also approval of Guwahati High Court for its publication, but did not allude to 6 schedule to the Constitution. On May 29, 2014, under orders of the governor, a further notification was published in exercise of authority under 1937 rules and on Meghalaya Autonomous District Administration Justice Act as amended and adopted by Meghalaya to separate the judicial from executive in the West Khasi district. By such notification, District and Session Judge Nonstein was appointed the Additional Deputy Commissioner of West Khasi for the trial of offences punishable with death, imprisonment for life, or imprisonment for term not less than 5 years under Indian Penal Code or any other law for time being applicable to district, except as Myran subdivision. It is such notification of May 29, 2014, the apparent question on the ground that the Criminal Procedure Code has not been notified in the state at the relevant point of time. There could have been no session division in terms of Section 9 of 1973. As such consequences, no position. As second ground of challenge is that the power to try criminal cases pertaining to heinous offences has already been conferred to the named judge by notification of August 10, 2011. Governor has no regulatory power to carve out a part of the authority and confer the same on any other court or officer. Reading of paragraph 516 schedule as per appellant is that all powers has to be conferred on one court or officer and not divided and conferred on various courts or officers. The last limb of the argument, through somewhat facetious, is that there is distinction between court and officer in paragraph 5 of 6 schedule of the Constitution. My Lord, kindly pause here for a moment, my Lord. All these issues, my Lord, whether it is Rivoi or whether it is Garovis or whether Jantia is, all the issue is common, my Lord. Notification pertaining to, so all 4 arguments which is being canvassed and before your lordship have already been fully addressed in subsequent paragraph. My Lord, kindly see, I will read paragraph 416. My Lord, kindly permit me to read it once again so that the issues which are being raised, my Lord, are covered by this paragraph. The issues are same which are being raised before your lordship. Now kindly see paragraph 16 once again, my Lord. It is such notification to me that the appellant question on the ground that since the Criminal Procedure Code had not been notified in the state at the relevant point of time, there could not have been no session division in terms of Section 9 of Code 1973. So first argument is, my Lord, that there is no notification of CRPC because in Contempt, my Lord, there was no notification of CRPC when trial has taken place. In our cases, my Lord, notification of CRPC has already been issued. So there is one fundamental. So this argument, my Lord, because in Contempt, when the case was tried, the argument was that there is no session court and therefore Rivoi, the district and session judge Rivoi, could not have tried the cases, my Lord. That was the argument because the argument of my learned friend was that there was no session court under section 9 of CRPC. Yes, my lord. So the second ground of challenge is, but therefore, my lord, if I succeed, my lord, here on CRPC notification has already been issued, and therefore power has already been conferred, my lord. Because we need not go into the academic issues, my lord, power has already been conferred, and those CRPC notifications are not under challenge before the lord. So therefore, regular district and session court has the power to try the cases. So that is my first link of submission, my lord. I will come to the second part also. The second ground of challenge is that since the power to try criminal cases pertaining to heinous offence has already been conferred to a named judge by notification of August 10, 2011, Governor has no legitimate authority to carve out a part of authority and confer the same on any other court or officer. So the question which was posed before the revision bench in my humble submission was that there is a conformity notification under paragraph 5(1) on district and district council court, and district council court is one only. So the governor could not have carved out jurisdiction for district and session judge out of district council law, because Riboi is part of district council of Khasi Hill autonomous district law. So governor could not have carved out a separate jurisdiction for Riboi district by notification, by conformment under 1937 rule, because there it was 19, that was the precise argument. And here, now second, the third argument was, my lord, the reading of power as per schedule is that power had to be conferred on one court. Third argument which was canvassed and argued was that there cannot be multiple courts which will have the power to try the offences.
All the power conferred on one officer or one court.
One court only. So the regular district and session court, my lord, cannot exist. This was the precise argument, my lord. The last limb of the argument, though somewhat, my lord, we are not concerned, paragraph 17, my lord. It must be pointed out that notification of May 29, 2014 clearly stipulated that such notifications should be stated earlier notification in respect of matters covered thereby pertaining to the statute. Because 1937 rules, my lord, provided that in supersession of all notifications, my lord. So now paragraph 18, my lord, to maintain the continuity, then there is a notification of March 17, 2015 by which a named additional judge of the district council in Shillong was conferred the authority to try the cases of heinous criminal offences. The next notification is of December 10, 2015 by which a named judicial officer designated district judge was appointed as additional deputy commissioner in Riboi. My lord, kindly mark the next notification is Riboi for trial of heinous offences. Notification is specified that all authority exercised by governor or in terms of rules of 1937, the Act of 1916, paragraph 5 or 6 of the Constitution. Notification further indicated that it was in supersession of earlier notification pertaining to relevant provisions in Riboi district. Paragraph 19. According to the appellant, in view of the 6th schedule of the Constitution, in which the District Council Court taking up all disputes between tribal and another tribal within the jurisdiction of District Council Court in the same area, and since by previous notification of August 10, 2011, Governor had conferred full authority to a named judge of District Court in Shillong. Subsequent notification of December 10 was an anomaly. Appellant also submitted the invocation of authority of Governor under paragraph 5(1) of the Constitution is flawed. To boot, the appellant maintains that since the particular judicial officer was named in notification of 10/2015, whatever authority was legally conferred by such notification was limited to the named officer and could not be exercised by successor in office. The last three notifications are of February 12, 2016, February 7, 2017, and May 3, 2018. First of such notification pertains to trial of heinous offences in West Jaisalmer district. Second of the notification pertains to additional judge in the District Council Court in Shillong. And third and most contentious is the notification of May 3, 2018, pursuant whereof criminal trial in cases was conducted. Notification seen in its entirety. In exercise of power conferred under Rule 1A of Rules of Administration of Justice, Police in Khasi Hill 1937, and further under subsection 1 of section 2 of Meghalaya Autonomous District Confidential Justice Rule, as adapted and amended, read with paragraph 5 of 6 of the Constitution, is pleased to confer the district and session judge Riboi with the power of additional deputy commissioner Riboi for trial of all offences punishable with death death imprisonment for term not less than 5 years under Indian Penal Code or any other law for time being applicable to district, and also here all civil and criminal provision, appeal, etc. from decision of the assistant to the deputy commissioner within the said district. And the governor is further pleased to direct the such district assistant judge and additional review of officer exercise all judicial power deputy commissioner within the said district with effect from date of joining. If this supersedes all notification issued to this effect under the aforesaid provision within the Goa district. So the issue, my lord, was that under the 1937 rules, power was conferred on district and session judges to try the cases, my lord, which was part of the district council area only, which is part of district council area only. Power was conferred on in 1937. You also have seen paragraph 5.3 of the constitution, paragraph 5.2 of the constitution, my lord, that the notification can be modified by governor as he deems appropriate. So therefore, my lord, and here, my lord, now notification under CRPC has already come, my lord, which confers power on all district and session judges. The earlier powers were being conferred under 1937 rules. Now powers are, once CRPC is notified, my lord, district and session judge by virtue of section 9 will have power to try the cases where the offence is punishable in sentence of more than 5 years, my lord. Now, the judgment of conviction in this case was pronounced on December 16, 2019, and sentence was also read out on the same day. 22. Two important factors must be kept in mind. First is that gradual and delayed transition of judicial authority from executive wing to the court, be it to the district council court in accordance with 6th schedule of the Constitution, or the regular judiciary as otherwise envisaged in the Constitution, the whole the 6th schedule there. The second aspect is seemingly parallel but not overlapping. Functioning of district council court and regular judiciary in state which is almost entirely covered by 6th schedule. A short but substantial answer to the doubts raised by appellant hearing could be referred to de facto doctrine, since irrespective of technicalities and perceived anomalies and the appellant cites the real intent and purpose of the law through the various rules and order notification have been to confer authority for trial of criminal cases by carving out niche in respect of special matters referred to in paragraph 5 of the 6th schedule of the Constitution. Further, the appellant application of de facto doctrine in this case appears to be appropriate, since nobody's case that serious criminal matter were heard by doctors or accountants or judicial officers or by judicial officers not of such experience or standing as would be in keeping with the spirit of Code of 1973. 24. There is, however, a more substantial answer, but before spelling it out, a recent healthy development in establishing the mastery of rule of law in this state must first be noted. It is heartening that in the furtherance of rapid strides all around, the state has made in recent times. Only time we have been praised. The Code of Civil Procedure and Code of Criminal Procedure 1973 have now been notified in the state by separate notification of September 2022. Notification issued under the authority of governor and exercise of power conferred under 1.2 is set up in pursuance of full separation of judiciary from executive and exercise of power conferred in proviso to subsection 2 of section 1 of Code of Criminal Procedure 1923. Governor of Meghalaya is pleased to apply the provisions of Code of Criminal Procedure 1923 to courts in the state of Meghalaya. All courts, my lord. District Council courts shall continue to derive power under paragraph 4 and 5 of the 6th Constitution. But power, my lord, as conferred, as modified, as altered, my lord. It's not that power is the Governor of Meghalaya further directs that the notwithstanding such application, all actions taken by the court throughout Meghalaya under the rules of administration of justice and police in Khasi and rules of so and so shall be deemed to have been taken under this, because we wanted to save those provisions. It's a saving clause, my lord, and it will also will notice in BNSS this similar provision is now no longer there, my lord. In paragraph 25, almost as an aside and before dwelling into the legal issues that have been raised by the appellant, it must be observed while the state may lack in development in healthcare, education, employment, industry, and certain facilities, citizens there can no longer be said to be backward or indulging in such practices as would rule out their integration to mainstream society, as was rather uncharitably perceived while labeling parts of the state and the entire northeast in general as backward areas, partly backward areas. It is true that happy people of the state of Meghalaya love and worship nature, but they also avail the latest benefit in information, technology, and ethnicity penetration up to the large benefit. There is no longer any primitiveness about the inhabitable state. They yield for all kinds of development that the rest of the country has experienced, much as others seemingly. Integration to make is complete. 26. Any assessment of doubt and issues raised by the appellant hearing has to begin with reference to two key paragraphs. There is no doubt that paragraph 4 vests the administration of justice in autonomous district with the district council court, but such authority comes with the two caveats indicated in between the parties, all of whom belong to scheduled tribe within such areas, and other than suits and cases to which provisions of subparagraph 1 or paragraph 5 of schedule apply. The word cases in the second expression would take within all fold in covered under 5.1 of the same school other than suit. My lord, I will just pause here for a moment. My lord, my friend is reciting the Supreme Court judgment, my lord.
Yes.
The Supreme Court judgment, the state took the plea, my lord, that the cases means only cases which are between two tribals, since one party is state in criminal matters, so it is not a dispute between two tribals. The state is a non-tribal entity and the private party is a tribal. Therefore, this was the plea which was rejected by the Honorable Supreme Court, saying that cases in fact means you are advancing the cases on behalf of the complainant, and therefore it is in essence between two tribals. So the ratio of that judgment is only on that score. So that is why my friend has not cited the judgment now. Before the lordship, he is saying he argued, that may not.
No, we'll examine it. But Richard Dakhar is followed in that case.
Yes, can you see? Now, 27. Paragraph 5 of the 6th schedule of the Constitution makes a clear distinction between criminal matters pertaining to trial of offences punishable with death, transportation for life, imprisonment for term not less than 5 years. In respect of such serious criminal cases pertaining to offences under Indian Penal Code or any law applicable to relevant, governor is empowered to specify the conferred authority on parties of the person. Such authority may be conferred on a district council having authority over such district or post constituted by such district council or any officer appointed in that behalf by governor. Since there is no regional council here, the reference of regional council, the provision is ignored. The last name of paragraph 516 of the Constitution emphasizes that it is only upon conferment of authority by governor in respect of serious matter, then the relevant court officers shall try the matter in exercise of powers so conferred. In other words, if the authority is conferred in accordance with paragraph 516, such powers cannot be exercised. That is only for interpretation, since the paragraph 4 of the 6th schedule, which apparently confers all power on village court and district council court, is tempered by excluding from such authority jurisdiction to try the cases to which provisions of paragraph 5 of 6th schedule apply. On the other hand, authority may be conferred on the district council or court constituted by such district or any other officer appointed in that behalf by the governor. Since it is clear that authority in terms of relevant provision may be conferred on the relevant district council or district council court, it needs to be emphasized that such authority may be conferred on any officer, provided such officer is appointed in that behalf by the governor. I pause here, Lord, that now district and session judge in Meghalaya are appointed by the governor, and by extending the BNSS, CRPC powers have been conferred on them to try the case.
So you mean without looking at any institution, once they conferred powers, the matter comes for them, they're competing to take it. That's all, to try it. Is that a lack? Is that a lack of?
There is one more caveat, my lord. Under Article 235, my lord, there is a provision to appoint district and session.
Yes.
See the Constitution of India, my lord. Article 235. So power has been conferred on District 235 of the Constitution of India, my lord. It is not that.
Yes.
Right now we are conferring power on district council court, my lord. 235, my lord. Sorry, 233.
Not 235 is.
Yes, my lord. Sorry, 235 is control subordinate. 233.
Control subordinate courts, yes.
Yeah, 233, my lord. 233. Appointment of persons to be and the posting and promotion of district judge in any state shall be made by the governor of the state in consultation with the High Court, exercising jurisdiction in relation to such matter. So therefore, this appointment is being made by governor in respect of each district under 235 million, and by CRPC and once CRPC is the statutory provision is extended under section 9, the session court has the power to try the cases, and then you will also kindly see the ratio of the judgment in paragraph 28.
Yes. Yes.
Last line of paragraph 28, my lord.
On
the other hand, the authority may be conferred on the district council or court constituted by district or any other officer appointed in that behalf by governor, since it is clear that authority in terms of relevant provision may be conferred on the respective district council or district council. It needs to be emphasized that such authority may also be conferred on any officer provided such officer is appointed in that behalf. In that factual context, my lord, in fact situation, the whole district and session judge tried the cases and power was conferred under 1937. So therefore, in that context, this observation has been made. Now, extrapolating these observations in the present situation, Lord, district and session judge have already been appointed and they have been conferred power under the CRPC and BNSS to try the cases. So therefore, to say that they are denuded of power under paragraph by virtue of paragraph 5, in my humble submission, is not correct, my lord. 29, my lord, ignoring to begin with the authority which is expressly invoked in issuing the disputed notification. It is evident that in each case the authority has been issued to a particular district council or to a named official named in district council or to a person appointed as district judge in terms of Meghalaya Judicial Service Code 2006. There can be no doubt that district judge being appointed under said rules of 2006 has been so appointed to take up such matters as district judges ordinarily would. Again, ignoring for this time being that at the time that the disputed notification was issued, the Code of Criminal Procedure 1937 had not been wholeheartedly embraced in this case. The constitutional authority of judicial system, except to the extent of autonomy granted to district council court, was same here as anywhere else in the country, and the district judiciary and its several types forming the base, the High Court exercising superintendent over the district judiciary and Supreme Court at the type of top of pyramid exercising primacy all over matters, my lord. Because your lordship, kindly keep in mind that there was no notification, and in that context the judgment and was being read, my lord, and this judgment also clarifies that situation, my lord. Thus, whether a notification named a particular district judge or referred to the office of district judge, conferment of authority by the governor had to be seen to be an officer appointed by governor in that behalf, that since the Code of 1973 had not been notified and session division had not been declared in accordance with section 9 of such code would matter little, because their argument was, now here we have got session division in terms of section 9 law. Appointments were made by governor on recommendation of the High Court to the post of designated as district assistant judge, and conferment of authority by governor was either to a person holding such post and generally to the office. There is no basis, 31, appellant once the authority in terms of paragraph 5 or 6 due to the constitution is conferred on a court or officer, governor has no regulatory power to carve out or the authority already conferred and vest the same some other officer or officer. Indeed, reading such limitation would defy the logic and would be an anathema to an efficient justice delivery system. For example, in a particular matter, the judge manning the designated post or named officer conferred the authority may desire to be recused. If the argument put forth by the appellant were to be accepted, that would imply that a particular matter would not be assigned to any other officer, and that would be go against the grain of paragraph 5.2 of the said schedule. It cannot be said that authority to assign a particular matter to another remain in some situation, and such authority is not generally available unless governing provisions provide such. If there is the authority to assign a particular matter to the another person of forum, it must be that there is a general authority to carve out portion of authority already conferred to bestow another decision. Similarly, there is no limitation on the power of governor in conferring the part of the authority, say pertaining to penal code, to particular code or officer appointed in that behalf, and some other special law to special code or officer appointed in that behalf. Plain and white amplitude of paragraph 5 of 6th schedule of the Constitution cannot be seen to be haste with such onerous condition as authority being required to be conferred on one code or officer or authority once confirmed not being capable of being modified, in part to carve out the class of matters to be placed before the altogether separate code or officer. And unsubstantial factual submission has been made on behalf of the land to satisfy notification so and so other criminal matters within the revolt pertaining to serious offences which are tried or may be committed within the jurisdiction of relevant district court, continue to be on the court of district council court. Since such factual assertion has been made deep into the hearing and just before the court, the state has not in position to respond and confirm what the appellant has claimed. However, in view of the second paragraph in both the notification of December 10, 2015 and May 3, 2018, the earlier notification pertaining to serious crimes within Rivoj district stands superseded and power previously conferred to the district and county court and particular offence can no longer be exercised to the extent it has been superseded. The 35. The other unremarkable point made on behalf of the appellant pertains to indication of source of authority in several notifications referred to here. While in the ideal situation, a statute and provisions conferring the power and the extent of such authority may be quoted while issuing notification conferring jurisdiction. The fact that the power to publish a notification is not indicated or an erroneous provision is quoted would make no difference as long as the power to confer jurisdiction is there. There is no doubt that power under paragraph 5(1) of the 6th schedule to the Constitution permitted referred to here and referred to be issued irrespective of whether such authority was indicated in particular notification or power invoked for such purpose was erroneously traced to some other rule or rate order. Whether under the rules of 1937 or under the subsequent rules or finally the Constitution, it is undeniable that it is the governor who has the authority to confer jurisdiction on courts and officers for trying serious criminal matters. As such, if the faulty nomenclature, the inappropriate invocation of the power or complete failure to indicate the authority for such power, if at all, pales into insignificance as it is evident that governor is possessed the requisite authority to direct the issuance of relevant notification. 36. Finally, there is an imaginary ghost that the appellant finds to be lurking in the second paragraph of recent notification issued to make Code 1937 applicable to all criminal matters in the state. The appellant apprehends that such second paragraph is disingenuous provision mischievously included in the relevant notification to regularize the trial and adjudication of all criminal matters that may have been conducted without jurisdiction as canvassed by the appellant in the present case. Since no irregularity, far less any illegality has been found in the conduct of criminal trials, in the present case, the validation of trial conducted in this case need not be on the crutches of the second paragraph in the relevant notification of September 2022, though it is not necessary to look into the basis for including the second paragraph. In the said notification, prima facie, it appears by way of abundant caution. At any rate, justification or efficacy of the relevant paragraph may be more appropriately assessed when it is into the service. My lord, the Honorable High Court refused to answer the academic question which my friend was trying to say, but that question also does not arise in this case, my lord. And therefore, what my friend is saying that the second paragraph has to be construed. If the question is, my lord, before your lordship, is that under paragraph 5(1) or under CRPC power has been conferred on district session judge or not, and whether this judgment squarely covers the issue before your lordship or not. If the judgment covers the issue before your lordship,
it ends there.
They cannot praise into the judgment of Supreme Court. I will place that Supreme Court judgment also, my lord, so for completeness of my argument, my lord. Now, 38, my lord. For the reasons aforesaid, there is no merit in the objection raised by the appellant as to the jurisdiction of the trial court in the case to conduct the criminal trial, adjudicate the matters, and pronounce its judgment and order in terms of notification dated so and so forth. Now, so thereafter, my lord, so if paragraph 3 to 38, my lord, in my humble submission, answers the entire issue which is raised, my lord. Your lordship, before your lordship, two facts are very clear. There are the transfers are being sought in cases where the offence is punishable with sentence of more than 5 years. That is
all of them.
Fact that all of them. All of them. My lord, if they are less than 4 years, 5 years, my lord, I will concede, my lord. They can't be tried. There is all of them, my lord. Because rape, POXO, all those cases, my lord. For example, POXO cases, my lord.
No, POXO can't special legislation. They have no jurisdiction. Yes, POXO, there is special legislation. It's like NDPS, POXO.
Yes,
you don't have to go there, yes. Yes.
And your lordship, kindly see stolen, this judgment, this will complete the stolen matter also. What was the argument of state?
Yes.
The stolen, Melvin stolen Pionda. This is 2020.
Is it reported?
Yes, yes. It's a reported judgment, my lord. 2023 FCC 711.
What other country?
My friend, I have, my friend.
No, I have.
They have annexed a
They have
copy.
annexed. Page number 72 of his affidavit.
20, I have given a copy also. The compilation in my compilation should be there, my lord.
In his affidavit, my lord, page number 72 onwards.
Where?
In affidavit filed by the learned HC. Additional affidavit filed on 6/9/2023.
No, the reported judgment or that's the printout from the
reported one he annexed.
Better to reported judgment.
Reported judgment he has annexed.
I found out while dictating judgments, sometimes the printouts are given from they are downloaded or
true
from
print and
not from true print. They're given from whoever downloaded. Then the paragraphs they will say, I say okay, quote para 38 from the judgment, so on and so on, and they go from the regular report, a totally different thing comes out. So I don't want that to happen. Yes, I got you. The citation is
72 of my page 72.
I got affidavit Jong State.
Page 72 annexure R5, my lord.
Affidavit Jong State. Page 72.
Yes, my lord.
Oh yes, it's here. Yes, very good.
Yes, my lord.
Yes.
Yes, Lord, kindly see.
Yes. Yes.
The respondent here, a member of the Khasi Procedural tribe, was tried for the offence punishable under 201 before the session judge. This was the fact. And Khasi Hill, the case set up by the prosecutor, the dead body was found lying on the so-and-so river bank, and person to which offence is charged. Upon the investigation, the identity of the deceased person was known, who was also found to be a member of Khasi tribe with the use of SIM card, etc. Also, there the dispute was between two tribes.
Yes.
Now, my lord, kindly see the paragraph 3, my lord, paragraph 3, paragraph 3, quote paragraph 4 and 5.
Yes.
Now, the paragraph 4.
Yes.
Paragraph 4, my submission, my lord. This is my submission, state submission, sorry, not my submission.
Relying on the
the learned counsel for the petitioner asked that under paragraph 4 of schedule 6, all of the parties to paragraph 4, my lord, paragraph 4, I'm sorry, after quoting the...
relying on the provisions. Okay.
Relying on these provisions, paragraph 4 of the judgment, my lord.
Yes.
The learned counsel for the petitioner asked to the Constitution, all of the parties to a suit or case must necessarily belong to civil tribe within such area for the district council court to have jurisdiction over such suits or cases. Given that a criminal case is always, he submitted that the instant case against the respondent cannot be said to be dispute between two tribals, as deceased is not and cannot be a party to such case. He also urged that complainant officer in charge at the police station can also not be considered party to the case, and he was acting in his officer. That forms part of the statement. So this was, and your lordship will kindly see one more line in paragraph 4 only. Relying on these provisions, learned counsel urged paragraph 4 of 6 schedule. So to some paragraph 4, not reference to paragraph 5, my lord, and that so this is the argument. Now, my lord, kindly see paragraph 7. Before we delve into the provisions of 6th schedule, it is to be noted that session court before which the respondent was facing trial is a court established and functioning under the provisions of Code of Criminal Procedure 1973. Notably, subsection 2 of section 1 of CRPC provides that the court has no application to tribal areas. At the same time, it gives the state government the power to extend the operation of CRPC to tribal areas as follows, my lord. So this was a fact situation where CRPC was not extended, my lord. Now that your lordship will find on page 7.1.
Yes.
7.1. As seen above, the expression tribal areas occurring in paragraph in section 1 CRPC refers to the areas indicated in 5th and 6th schedule of the Constitution. Of a notification by state government extending the CRPC to such area, except 3 chapters referred above, provisions of CRPC are not applicable to tribal areas in the state of Meghalaya, including Khasi and Jhansi. So this was the backdrop in which.
Yes.
And 7.2, my lord, is only, this was the backdrop in which the court held that the regular session court has no power, my lord.
Yes.
Your lordship will see then paragraph 9, because it refers to conformment. CRPC was not applicable, my lord, and the Honorable Supreme Court In the instant case, exercise of power under paragraph 4 of schedules, the United Case rules were adopted, rule 9 thereafter. Again, because there was a error on the part of the state also to refer to paragraph 4 and the rules which are under paragraph 4. Rule 9 thereunder provides all these are rules relating to paragraph 4 of the Constitution.
Yes.
Now, in detail of paragraph 5, in exercise of such power under Rule 9 and paragraph 5.1 of schedule, a notification was published on 7/2, which Governor of Meghalaya appointed an additional district judge of District Court, Council Court, Shillong, and conferred her with the power for the trial of offences punishable with death, transportation for life, or imprisonment for a term of not less than 5 years. In the light of such a specific conferral on power of District Council Court, Shillong, the issue examined whether jurisdiction to try cases against the respondent rests only with the District Council Court. As mentioned in paragraph 4, the trial, my lord, 4 is referred, and then 10.3, my lord. Under paragraph 5.1, Governor is invested with the power to confer district and regional council, power set up by district council or any officer appointed by governor in that behalf such power under CRPC and CPC as he deems for trial of certain suit cases. The conferral of power under CRPC in certain instances has been done by notification of 7/2. Here makes it amply clear that District Council has jurisdiction to entertain such cases, notwithstanding the fact that state is de jure complainant in such cases and cannot be considered tribal party. In fact, it is reflective of so. So the ratio of this judgment is, my lord, the state cannot be treated as tribal parties, my lord. And CRPC has not been notified, my lord. Kindly see. Paragraph 10.6.
No, but this runs contrary, the Richard Dakar then is contrary. Because if a complainant, it does not go to the state, is the complainant. The complainant is a tribal, but the prosecution is done by the state. And so the case considered in tribals. But that's not been addressed. You won't understand this aspect.
Yes, that your lordship is right, but we can't help it, my lord. Because,
yes, of course. I'm just airing my mind.
But yeah, your lordship is right. My reading of the judgment is same also, my lord. But the fact is, my lord, that 10.6, your lordship, in the instant case, it is an admitted position that because the argument was not placed, 1937 rules was not placed, nothing was placed, my lord. It was before I became legal. Mr. Mukherjee.
Yes.
Because he was not familiar with the rules and provisions. 10.6. In the instant case, it is admitted position that victim and the accused respondent both belong to Khasi tribe. Thus, given there is a specific notification that confers district council with the power CRC so and so, we find such position in so and so. This is the context, my lord, and this is the context in which the judgment has been passed. So, ratio of the judgment, my lord, is that the state is a tribe and there is a notification and CRPC has not been notified. And that's why my friend has not cited the judgment, not relied upon the judgment before division bench. And before your lordship, they are making issue by saying that the judgment has not been considered, my lord. If my friend can point out how this judgment after 1937 rules notification can be applied, my lord, and each and every issue, my lord, with respect, my lord, has been covered by the division bench judgment, my lord. I will cite one judgment, my lord, on the per incuriam issue, my lord. Kindly see this 2015. My friend will give the copy, my lord. 2015, 2 SEC 727. Please supply the copy.
2015?
2 SEC 727. Paragraph 7, you lordship will see the paragraph 7, facts in brief, my lord. Government Council appearing for the appellant imply union had submitted, and this court, High Court has committed a grave error by reconsidering the issue which had already been decided by this court. Once the court has decided that the employees society were not entitled for so and so, could not have come to different conclusion, my lord. That the High Court came to different conclusion, my lord. And then if your lordship will kindly straight away see paragraph 15. The 115, paragraph 15, 15. If the view taken by the High Court is accepted, in our opinion, there would be total chaos in this country because in that case there would be no finality to any order passed by this court. When a higher court has rendered a particular decision, said decision must be followed by subordinate or lower court unless it is distinguished or overruled or set aside. High Court has considered several provisions which in its opinion had not been considered or argued before this court when CA number was decided. If the litigants or lawyers are permitted to argue that something was correct, what was correct and what was not argued earlier before the higher court, and on that ground if the court below are permitted to take a different view in a matter, possibly the entire law in relation to precedent and ratio decidendi will have to be rewritten, and in our opinion that cannot be done. Moreover, by following the law laid down by the court, High Court would also be violating the provisions of Article 141.
No, that's a given.
Yeah, Milord, and this constitution-based judgment also.
You have concluded arguments. I mean, that's it, I guess.
I only the constitution-based judgment, Milord. If I can show other provisions also, but
yeah, of course. For an curium judgments, I don't think you need to show any other authorities. But I mean, if you have anything else.
If you want to take note of the constitution-based judgment, just note the citation only, Milord.
Yes.
2024 SEC.
2020.
Page 1, Milord. 2024 SEC. Page 1.
Yes.
Paragraph 16, 23 and 27. This is a constitution-based judgment, Milord.
Okay.
So my argument, Milord, is that issue is squarely covered.
No, we understand that, Ms. Harpreet. Only that we're giving the opportunity, if they can distinguish or, in any manner to show that this judgment of commercial will not squarely apply to them. If the points have all been addressed, then our hands are tied. You have to go somewhere else.
They can challenge it in division between.
Yes, they can.
Go
Anyway.
They can go up.
No, will reply when, today or tomorrow?
Tomorrow also. To Lordship convenient. Tomorrow also.
We'll reply tomorrow, we'll conclude tomorrow.
Yes, we can conclude tomorrow. Yes.
Yes. I'll listen for the hearing tomorrow, yes. Tomorrow is Thursday. All right.
Thursday.
Flip untuk pet system ini. Ada flip stapler sudah untuk flip stapler orang pen. Yes. What will complete tomorrow?
No, we'll complete tomorrow.
Yes, we can complete because the issue actually is.
The case has been held for a long time.
Yes,
at least if it can be possible over the weekend to.
I'll report, my lord. In first matter, relevant witnesses have already been examined, my lord.
Yes, no, we understand that. We understand that. It's been unduly held up, and it's not a.
Yes. Item 22.
Okay. Yes. Yes.
My lord, here we are filing an objection. I think we have filed it.
What objection?
Against the impleading of.
Full file
My lord,
impleading?
corporation has filed a miscellaneous application for impleadment, my lord.
For
We have filed one in this case.
Where is that? Case number 9.
Case, my lord, this case number is 9, my lord.
Where's the objection?
We are filing it today, my lord. So let it come up.
Okay. To the application for impleadment filed by the Meghalaya Power Distribution Corporation Limited bracket MEPDCL Learned Senior Counsel Mr. Tino submits that objection to same be filed in the course of the day. This is matter after 1 week in the order column.
Yes.
23.
Yes. Where's Mr. Yubin?
Sir, we have ready the check that we.
Give the check to her.
Yes.
Yes, Your Lordship.
The check is with Mr. Yubin.
You're not ready to give the check?
No, with Mr. Yubin. The check is ready, but he's with Mr. Yubin.
He's gone to encash it, or he's kept his pocket?
He thought that the case is item 15 is
to the school in question, along with restoring actual position. There to stop. in the course of hearing and after, in the course of hearing the counsel for the parties and view the fact that the petitioner is no longer in the employ of the respondent school, on the suggestion of the court, the respondent number 5 had calculated the salary as admissible petitioner less the amount she had already been paid for services rendered. How much is the check giving?
1 lakh.
1 lakh. Next one. Though there was objections from the part of the counsel of the petitioner as to the amount, but in consideration thereof, today on instructions, an amicable solution has been arrived at, whereby the petitioners agreed to accept rupees 1 lakh as a final and full settlement for the services rendered to the school. The check in open court has been handed over to the counsel for the petitioner. Yes, photocopy whereof shall be supplied to the court master for placement in the records. So, and accordingly, in view to said developments, the matter stands closed and disposed.
Deeply obliged, Lordship.
You take the check, give photocopy to the court master, she'll place it on record.
25.
All right.
May it please your Lordship. Lordship, as per the order dated 28 March 2023, we were supposed to seek instruction from the department as regard to the posting of the petitioner, Lordship, and we have obtained the instruction and we have placed it in the form of an application. It was filed on 5th March 2024. As regard to the vacating the interim order dated 28/3/2023, Lordship. Lordship, I humbly pray if you may kindly take up this matter after a week, because after 2 weeks, learned DSJ.
Yes, he's had an operation.
Yes, ma'am. I visited.
On the request of the learned counsel for the respondent due to absence of the learned DSGI, this is a matter after 2 weeks.
2 weeks, Lordship.
You've given copy application to him?
Already served.
You file objection also?
No, I will file.
As is further submitted by MSA Pradhan that an application for vacating the interim order has been passed. Mr. Arjha, please be allowed
to file this.
He will be allowed to file an objection to the same in the meantime.
Ma'am.
Highly obliged, Lordship.
Yes, accordingly on so and so.
26.
Yeah? George. Yes, Mr. Chakravarti.
Please, Your Lordship.
What is the matter about forgotten contract?
This is coming up for the first time, Lord.
For hearing?
For hearing.
Okay.
It has not reached till now.
Okay. Name familiar. Oh, no, name familiar, other situation. When we were at the receiving end. Yes.
Milord, here, Milord, the here has implemented the state through the secretary law and the
law.
Secretary law, Milord. And Milord, and there is a private respondent.
Yes.
Milord, here basically the relationship between the petitioner and the private respondent is of tenant and landlord. The petitioner is a tenant under the private respondent. Number 2. Now, Milord, this basically, Milord, during the time of COVID, Milord, the Honorable Supreme Court had given a
blanket is blanket, sort of a blanket freezing time, freezing the time.
Yes, that means the limitations which have been
will not run.
That will not run. I mean, up to a certain period, up to 28th of February 2022, the Honorable Supreme Court had given the ban on the running of the limitation. So now, my lord, in this case, the point which has been raised is that this under the Rent Control Act, Urban Areas Rent Control Act, there is a time limit prescribed for deposit of the rent in the court.
Yes.
Deposit of the rent in the court, my lord. So, in keeping with the judgments of the Honorable Supreme Court, my lord, here it is prayed that because the rent could not be deposited during that period and after that period also, it could not be deposited. So, a prayer has been made here, my lord, to allow the petitioner to make a deposit at one time. What is the areas of rent which is accumulated to allow the petitioner to deposit as a one-time measure the whole amount of rent which has been accumulated. So that is basically the case is that, my lord. My lord, here, my lord, the urban areas. 17 running page.
Yes.
And subparagraph 4, if your lordship comes, where the landlord refuses to accept.
5 sub.
On the 17.
Yes.
Where the landlord refuses to accept the lawful rent offered by.
Yes.
The tenant may, within 30 days of its becoming due. So this is the limitation prescribed, 30 days. Deposit in court the amount of such rent together with process fees for service of notice upon the landlord, and on receiving such deposit, the court shall cause a notice of the receipt of such deposit to be served on the landlord, and the amount of the deposit may thereafter be withdrawn by the landlord on application made by him to the court in that behalf. A tenant who has made such deposit shall not be treated as a defaulter under clause E of the proviso of subsection 1 of this section. So this is the provision. Now, my lord, because of the COVID, of the pandemic, my lord, there was a disruption in the functioning of the courts, and everything was disrupted, in fact, my lord. And the last deposit of rent which was made by the petitioner here was for the month of January 2020.
Just before COVID.
Just before COVID. With effect from the rent of February 2020. From March, my lord, the whole thing closed down. So, with effect from the rent of February 2020, he has not been able to pay the rent.
Yes.
Now, my lord, he is before your lordship now, the petitioner is before your lordship now, that he, because of the disruption of that period, my lord, and thereafter, of course, subsequently the Honorable Supreme Court for the period of the pandemic, for that period, the limitation, probably that will apply to this limitation also. If I take your lordship to the judgment also, we have annexed in the next page, my lord. If your lordship comes to running page 21.
Yes.
21 para 5, my lord.
Yes.
Taking and the impact of the surge of the virus on public health and adversities faced by litigants in the prevailing conditions, we deem it appropriate to dispose the miscellaneous application number 21 of 22 with the following directions. The order dated 23/3/2020 is restored, and in continuation of the subsequent orders dated so-and-so, so-and-so, and so-and-so, it is directed that the period from 15/3/2020 till 28/2/2022.
Yes.
This period, my lord, shall stand excluded for the purposes of limited be prescribed under any general or special laws in respect of all judicial or quasi-judicial proceedings. So this period has been excluded, my lord. Now, my lord, consequently,
which order is this? Who passed this order?
My lord?
This order is from the Supreme Court.
Supreme Court.
Yes.
This was, my lord, originally the Supreme Court had taken up a suo moto.
Yes, and we had just cut piece. I mean, they just followed them.
We just followed.
Allowing, yes.
We just followed them. So, my lord, during that period,
what's
my lord,
the problem here?
So here, my lord, after this period, the relevant period here is that after this period, my lord.
After 22.
After 22, my lord.
You didn't pay.
It was not paid, my lord.
How long?
My lord, because it is until and unless we deposit, my lord. Until and unless we deposit.
Yes. Yes.
No deposit can be made. So it would be up to date, my lord. With effect from February 2020.
No, okay, we cut out 22. Why didn't you go and then deposit after 22?
That is what, my lord. That deposit was not made.
Why?
Now before your lordship, my lord, since the initial deposit was not made. So because there has been some lapses on the part, my lord, after this period. That means after 28 to...
What stage is the suit?
Suit, my lord, is that is a eviction suit that is going on.
What stage is it?
Now, my lord, probably the suit is in the evidence stage.
Oh.
Evidence stage, my lord. With defense witnesses stage, my lord.
Okay.
So, my lord, here only one prayer is there, my lord, because in line with the decision of the Honorable Supreme Court, my lord, in keeping with the spirit of the same judgment, my lord, if we may be allowed to make a one-time deposit. That is the prayer before your lordship.
When was this matter filed? 18?
It was May
one year after.
23, my lord.
So,
may it please your lordship. First of all, your lordship, that the petition has been filed under 226 article.
Yes.
Whether the 226 will be maintainable or not.
You didn't file any objections to maintainability?
Yes, I have filed, your honor. Yes, lordship, I have filed.
Where is
The
your petition?
affidavit is there, your lordship.
Right.
I have filed affidavit. The first question is, your lordship, that whether 226 is maintainable here.
Right.
Because here the dispute is between two parties, landlord and tenant.
Yes.
So how the state will come here, your lordship? The first question is that. The second question is, your lordship, that they are filing rent. They are paying rent. They have not paid rent since 2018, your lordship. Since 2018, they have not paid rent. But in their petition, they are mentioning that they are paying rent in the court. In petition, para number 4 of the petition, they are stating, your lordship, that they are paying rent in the court. But there is nothing on record that they are paying rent in the court. There are nothing on record, your lordship, that they are paying rent in the court. And if they are paying rent in the court, then why not again they would have approached there? That the lower court again have the jurisdiction, the inherent power under 151 CPC. At the same time, your lordship, they are defaulting rent from February 2020. That time there were no COVID, your lordship. They have paid the rent till January 2020, your lordship.
They have paid?
They are saying, their claim is that they have paid the rent. As per me, your lordship, they have not paid rent since 2018. And that's why I have filed a eviction suit also, your lordship. It's pending before the Assistant District Judge, Shillong. But their prayer is that they were paying rent in the court, but nothing is there on record. And since February 2020, they have not paid rent. And they are taking plea of the COVID, your lordship. Again, your lordship, okay, due to COVID and all, they have not paid the rent. Well, the Supreme Court judgment they have referred, Your Lordship. That judgment said in para 22, Your Lordship, page number 22. Page number 22, para 5, sub-para 3. It said, Your Lordship, in cases where the limitation would have expired during the period between 15/3/2020 till 28/2/2022, the limitation has been waived off, Your Lordship, till February 2022. Notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. Again, Your Lordship, the entire 20 and 21, the limitation period has been scrapped till 28 February 2022. And again, Your Lordship, the 90 days grace period has been given. So it means February, again 90 days means 3 months till May. Approximately till May, they would have paid the rent without coming to this honorable court and without coming and filing the condemnation or anything, Your Lordship. But then also they have not paid, Your Lordship. Again they have defaulted, till date they are defaulting, and they came after a year, Your Lordship. They came before this honorable court after a year by filing the writ petition number 226.
Yes.
And that petition has been preferred in May 2023, Your Lordship.
Yes.
May 2023. And again, same thing, Your Lordship, another point, Your Lordship, that if they have approached the lower court to file the writ, if they have refused, the lower court would have refused, they have the power, they have the right to appeal, Your Lordship, under section 8 of the same section the learned senior was quoting. The order is appealable, Your Lordship. Then how the 226 will come?
Yes.
And why they came in the month of May 2023 before this honorable court, Your Lordship, because their agreement was expiring next month on 11th June 2023.
The lease agreement is over.
It's over, Your Lordship. Already in 11th June 2023 is over.
Yes, we're just going on this. Anyway, it continues.
Yes, Your Lordship. 2023, 11th January 2023, the lease agreement has been, it was for 15 years, Your Lordship, and that 11th June 2023, the lease agreement has already been expired.
Okay.
And just before expiry of the lease agreement, nearly 15 or 20 days before, they have filed the petition. So they have already defaulted, Your Lordship. Prior to COVID also, they have defaulted the rent. After expiry of the COVID also, again they have defaulted. The entire COVID, 2020, 2021, they have not paid. 2022, they have not paid. 2023, till May, they have not paid the rent. And till date, they have not paid the rent, Your Lordship. And they are taking the plea under 226 article, Your Lordship, which is not maintainable at all.
Miss State, nothing to say.
We have no role in that. But the important question is how is 226 maintainable, but that apart, there are certain orders that Lordships had passed. The COVID-19 proceedings. So Lordships, the first order is 27/3/2020.
Yes.
The Lordships had suspended limitation. And you have the next page. Para 5 relates to interim orders, which are passed in judicial proceedings. So limitation was suspended in respect of those orders. Then, the interim orders were extended. Para 6 related to criminal proceedings, and para 6 and para 8 related to orders of government institutions. Now this does not relate to deposits under section 5 of the Rent Control Act. So this was brought to your Lordships notice on 15/6/2020. This is in the next page, and Lordships taking note of that, pass certain orders at para 3.
Yes.
So the benefit of depositing rent was granted in these proceedings by an order dated 15/6/2020.
Yes.
These were extended from time to time, and they finally ended on 2/2/21, which is the last page.
2/2/21?
2/2/21 is the last order, the last page.
Okay. Okay. Anything else?
This is a matter of private.
We'll pass orders.
Regarding the maintainability,
Anything to say?
regarding maintainability, my lord, my only submission is that because it is a law made by the state, and we have come with regard to the law made by the state, my lord.
Yes.
That is why the secretary, the state has been made a party. Our primary case is against the state, my lord. Primarily, our case is not against the respondent number 2.
How?
Because, my lord, here the limitation is prescribed by a law made by the state, and we want a condemnation of that that law which is made by the state. Our grievance is mainly because of the law which is in force, my lord, and we want your lordship's interference for granting our prayer, my lord. Our prayer is that that may be condoned.
That's noted.
So that is why, because our case is against the state, and here the state is not objecting to it.
Yes.
State is not objecting to it. My lord, the private dispute between the respondent number 2 and us, that is beyond the
scope
of this particular petition, my lord.
That's it.
That is what. So it is a maintainable.
We'll pass orders. Yes.
Obligement.
Hearing. Yes.
Supplementary 1.
Deeply obliged.
Item number 1.
May it please your lordship.
Yes. Where's the eviction notice?
Lordship will find that at Annexure 6, your lordship, page 38. Lordship, this is with regard to the expansion of the Tura Dalu road.
Yes. Yes.
Lordship, the preliminary notice for this acquisition of this land, Lordship, was issued way back in 2019, your Lordship.
Yes.
Lordship, that your Lordship will find at Annexure 2,
Yes.
page 27, your Lordship.
Right. Then?
Lordship, where various Aking land was to be acquired, your Lordship. The list is in the bottom of the page, your Lordship.
Right.
Annexure 2, page 27. Lordship, the Aking in which my land falls, Lordship, it's called Mekungre Aking. And Lordship, that is at page 28, next page, your Lordship.
Yes.
My name appears at 16, your Lordship.
Victrola Sangma. Okay.
Lordship.
Right.
Now, what is pertinent here, your Lordship, is if your Lordship is pleased to look at what is sought to be acquired, your Lordship, the columns. First is under design chainage. I'm not on that, on the first two columns, Lordship. Then the next column is length in meters, Lordship. If your Lordship has got it, 14 meters in length. Next column is width, your Lordship. That is 00.
Yes.
And the next column is area and square meters. That's also 0, Your Lordship.
Yes.
So Lordship will kindly look at this chart. In most of these cases, Your Lordship, what is sought to be acquired, only the length is indicated and there is no width. And as such, what is the area which is sought to be acquired is also shown as 0.00.
Yes.
So this was the preliminary notice, Your Lordship, inviting objections, to which, Your Lordship, way back on 5th September 2019, Your Lordship, we filed our objections. That's at page 29, Your Lordship.
Yes, this is by this
Raising all
petitioner.
this was one of the issues, Your Lordship. But in spite of receiving our objections, Your Lordship, it is not only me, several others have filed these objections, Your Lordship. But we have not been afforded any hearing on our objections, Your Lordship.
When was this filed? 2019?
Lordship. The notice, the preliminary notice is also 19, and immediately thereafter, Lordship, we filed our objection on 5th September 2019.
Okay,
Till
then?
date, it has not been addressed, Lordship, and meanwhile, Your Lordship, they have proceeded by giving some compensation to some people, but there is no proper acquisition proceedings. And as such, Your Lordship, several people have also approached this Honorable High Court, Your Lordship.
Yeah.
One of the petitioners who are before this High Court is one Srimati Nemi Sangma, Lordship, in which Your Lordship was also pleased to direct, Lordship, I have annexed that order. Lordship was pleased to direct that the petitioner should be given the opportunity to be heard. Lordship will find that at page 41, the relevant portion of your Lordship's order.
41, yes.
Page 41, Lordship, the first part of the last line, may I just read that? Furthermore, as stated in the affidavit, the process of compensation is still not complete, and it is expected that the petitioners be given a chance to be heard and present their case as and when they are called upon by the district collector. But in spite of this direction, Lordship, this direction was in 16/12/21. Thereafter also, Lordship, I personally have not been afforded any opportunity of hearing, along with many others. And one fine day, Lordship, on 2nd July, Lordship, that is at page 35, the Deputy Commissioner called for a meeting to discuss the meeting on acquisition of land, Tura Dalu Road.
Yes.
Which again, Lordship, substantiates the fact that the acquisition proceedings have not been completed, nor any compensation given. Lordship, this is further proved by the fact the next page, page 36.
Now, did he get his notice? Number 8, land structure owners, KM 85 is 10 kilometers only. 10 kilometers and 4 kilometers, 14 kilometers.
Lordship, there are several landowners along this
naturally,
stretch,
85 to 90.
including
yes.
myself, Lordship. So
Right.
these are general notices.
Now
which are
this
issued.
is the one who came to the meeting, 36.
Lordship,
What's the 36?
now 38 has been issued. Now
No,
38
one
has been
second, one
issued.
second. Just page 36, what
36,
36 is?
36, Lordship, will see on top ERS structures who have not received compensation. So,
No, whose
again, it
document
proves that
is this?
Lordship, this is the notice. This
It's together with the notice.
accompanies the notice on page 35.
Okay.
This is a notice for
Your
a
name's
meeting
there also.
on acquisition of land in Tura Dalu Road, where generally people were called to the office of the Deputy Commissioner, Lordship.
Your name's here also.
Where I
33.
also went.
Okay, you went.
I went, Your Lordship,
Then
but
what
our
happened?
objections were not heard. And thereafter, Lordship, this impugned notice, Your Lordship, dated 15/12 July 24, was issued. Lordship, I received it on 25/7/24. On top, my signature is there. But this is just a general notice.
You get instructions. What is this?
Just two things, Lord. Kindly have para 6 at page 12.
Of the petition.
Lordship. So their case is that as against the section 11 notification, which was published on 27/6/2019, they filed a written objection. So kindly see what this reads. That the petitioner states that thereafter the petitioner, along with other affected people of Mengongre Aking, had filed a comprehensive objection dated 5/9/2019 before the respondent number 3, against the purported land acquisition process initiated by the respondent authority, vide notification dated so and so. It is pertinent to mention herein that despite filing objections, no response whatsoever was received from the respondents, and till date, the respondent authority has failed to address the grievances of the petitioner. And then kindly see page 15, para 12. 12 minutes. Yes. That the petitioner submits that the manner in which the respondents have initiated and dealt with the purported acquisition proceedings, particularly in case of the land of the petitioner, smacks of anomalies and overreaching of their jurisdictions, not vested on them by law, inasmuch as there was no lawful acquisition per se of the land belonging to the petitioner, and besides, there was no hearing of objections filed by the petitioner, and no declaration under section 19 has been made by the respondent authority as contemplated under the so and so. Now, if your lordships also see the objection that was filed, 5/9/2019, that is at page 29 of the application. The substance of the objection is at para 4 and para 5. Para 4 reads that it may be observed that in para 4 of the patta issued by the JHDC to the landholders has mentioned that the stretch of so and so meters of land should be surrendered for the cause of development in the public interest, but whereas nothing sort of notification nor the Land Acquisition Act were never followed and conducted to acquire such land, plot or areas by the JHDC. This relates to the acquisition of the ROW. Lordships are aware that matter is pending before the Honourable Division Bench. Now kindly see the signatory, Matthew M. Sangma. He is one of the parties who's filed that writ petition that is numbered as WPC 131 of 2023. That entire subject matter is pending before the Division Bench. The second issue that they've raised at para 5, can you see that in spite of all those commissions and omissions committed by the JHDC in the matter of land acquisition earlier, it is also observed that the survey were hurriedly executed in the absence of most of the landowners, who are now unaware of the actual length or width being included for the project. Hence, the land to be used for the project must be clearly and visibly demarcated before commencing the civil works. Further, it may also be requested that published and notified as done by the SARDP project South Garo Hills District by mentioning the actual length with class of land, rate per square land value, factors by which such market value is multiplied, 100% compensation, 12% interest. This is on the question of valuation. That can't be considered the stage of section 11 or section 15. Now they've also made the statement that the section 19 notification has not been published. Because I'm in possession of the section 19 notification, which was published on 8/6/2020. So, Lordship will see the identification of the land is the same, whereas it appears that the government that a total of 82B 3K 11L 11067.52 square meters of land.
Megongre is here.
And Megongre is mentioned here. Now, kindly see the second last paragraph.
Yes, okay,
This declaration is made under section 19 of the Act after hearing the objections of the persons interested and due inquiry as provided under section 15 of the Act. The number of families likely to be resettled due to the land acquisition is nil. This is not under challenge.
Yes,
Now, they've said that the section 19 notification has never been published. But insofar as Megongre and for the same particular chainage, the 19 notification has already been published.
Are you aware of this?
No, Your Lordship, we are not aware because Lordship will kindly note the objection which has been filed, Your Lordship, has been jointly filed by several landowners, Lordship. This is not common objection
one thing,
filed by the
Paul,
Archival of
listen,
Meghalaya.
this declaration has been made in 8th of June 2020.
Lordship, we are not aware of it because our objection, the initial objection, has not been addressed.
But this is a public document.
But
if you are aware of the section, the earlier notification 11.
Now, in fact, in respect of the other writ petition, which is pending in court number 4, most of the parties names have been struck off because they've already received their part of the compensation. They voluntarily filed applications for striking out the names.
The fact that we have not received any compensation is evident from the notice issued by the Deputy Commissioner, page 36, Your Lordship.
I've taken instructions insofar as that is concerned. They have refused.
With regard to the people who have not received compensation. And I will also read the impugned notice, Lordship, at page 38. in the second last para, Your Lordship. Page 38, second last para.
Yes.
Lordship, it is hereby also notified to all landowners who are yet to receive compensation to claim the same from the Revenue Branch DC Office, West Garo Hills, Tura at the earliest after submission of the requisite documents. So the fact
but
remains
if
that
the
you have
other
not
people
received
are not
compensation.
aggrieved, see.
So I have taken instructions, well, there are
Several
certain
people are aggrieved, Your Lordship. It's not that they are not aggrieved, it's only that they have not been able to approach this Honorable Court yet, because this notice was circulated, though it is dated 15 July, Your Lordship, it is only on 25th July it was received by me and by many others, Your Lordship. So asking us to vacate by today or else penal action will be taken against us, besides removing the standing structures on the land, Your Lordship.
What is this other document?
Kindly see, this is a meeting of
20th
February 2020. So most of the landowners were asked to come and appear before the DC for a meeting. Kindly see the last line in that first paragraph. Unfortunately, the complainants, stakeholders, could not attend the meeting due to unavoidable circumstances. I've just spoken to the DC for instructions. There are several people who already accepted their part of the compensation.
There are other cases where some are accepted,
Yes.
some not accepted, yes.
Lordship, so in this case, this particular petition and
Yes,
several
I think
others,
somewhere,
they
yeah.
are creating problems. They're not vacating this ROW. The entire dispute in this case relates only to that ROW, nothing else. And the GHDC has made it very clear.
Acquisition is
You
not
do one
complete.
thing,
Compensation is not. Lordship.
See, we'll do one thing is that, as he said, it just got noticed today, and you don't have, MSA Paul, the thing is that this is, this section 9 declarations there in the 19.1. So whether it covers you or not,
Lordship,
this is
shall
the
have it
entire
done
document.
because,
Yes, my lord. I have taken instructions. I'm not sure if this is the entire one. I have a copy of this from Matthew Sangma's application. Matthew Sangma has filed a writ petition, which is pending before the division bench. This is from his writ petition. But this also mentions the same particular
This we are
identification,
not aware, Your Lordship.
and it also includes Megongre village.
Okay, we'll do one thing. You get proper instructions with regard to specific writ petitioner. You'll get limited stay till next week.
So only insofar as this petition.
Obliged.
Only for petitioner, yes.
Obliged, Your Lordship.
Yeah. Otherwise, then your matter is, yes, heard MS Apol and Senior Counsel with MS R. Datta for the petitioner. Stop. By the present writ petition, the writ petitioner has assailed a notice dated 15 July 2024, which had been issued by the Deputy Commissioner, Revenue West Garo Hills, respondent number 3, asked a persons in the stretch of land from KM 85 to KM 95 and from KM 101 to KM 145 of the Tura Dalu Road section of NH 51 to vacate such land or structures by 31/7/2024 as the same is as construction is to commence for widening of the said highway. Stop. Next paragraph. It has been submitted by the senior for the petitioner that the writ petitioner, how much do you occupy this?
Lordship, it is mentioned in that initial notice, Your Lordship.
It
Lordship will
is
kindly find that
submitted
at
by the
page
Senior Counsel that
28.
the petitioner herein is in possession of 14 meters running length alongside the road, and that the grievance and the grievance is that without due process of law or proper acquisition proceedings, a notice has been served upon them. It has been further submitted that the writ petition has never been heard, though there are orders from this court directing that all concerned people be heard before any further action was taken for handing over of the right of way to the NHIDCL. She therefore prays that as far as the petition is concerned, the impugn notice will not be kept in abeyance. Next, para Mr. S.N. Leonard G. appearing for the state respondents has, however, submitted that due process has been carried out inasmuch as a declaration under Section 19 had also been issued, and further that the same subject matter in question is pending before the division benches of this court for consideration. He therefore submits that no interim orders are called for at this stage, and that he may be allowed to obtain instructions. Next paragraph, having heard the counsel of the parties and having examined the materials on record, as the matter concerns demolition and eviction, it is provided that till the next date, the notice dated 15 July 2024 issued by respondent 3 as far as petition is concerned, as far as the plot of the petitioner's land is concerned, shall be kept in abeyance to enable the NHGA to obtain proper instructions.
The clarification will not apply to anybody else, my lord.
Yes,
because they will take undue advantage
as far
of
as
this.
concerns the writ petitioner. Yes. Yes, MSA Pradhan is present on behalf of respondents number 4, 6 and 7. 4, 6 and 7, and MSN Raji is present on behalf of respondent number 8. List the matter on
Tuesday, my lord.
On
You'll obtain instructions by Tuesday.
6.
Obliged.
Obliged, my lord.
For further order.
With due applause, Your Lordship.
Yes.
Your Lordship, I have filed 2 citations, Your Lordship, latest citation. Your Lordship.
Very good. You give it.
Deeply obliged.